Just make me a presenter. Yes, presenter. So I guess yesterday there was another session on case laws, right? Uh,
Yes,
this
sir.
session,
It
please.
was held yesterday.
So yesterday you had covered mostly the cases, or you had covered mostly the theory part?
Only the case laws were covered there.
And case, okay. And case laws, maybe one of the participant can tell whether they were only related to PG or they were related to all over. I mean,
All over, sir, not PG.
not PG. Okay. So then I think let us start our session. We have 3 hours today, and I think we have 18, 19 people with us already. Uh, I will try and cover the PG part, personal insolvency part, plus the case laws which are particularly related to personal guarantors. So we will not do hundreds cases and all, because then nobody remembers anything. What we will try to do today is we will take up 10 cases and what exact those 10 cases have said so far. So the law as it stands today. That's what we will try to learn today. And participants, I assume all of you are IPs, IP Arunji, Shradhenu, Hemi Gupta. Okay, so Anil ji is also here. So I think all of you are IPs.
Yes, sir. Yes.
I'm sure this is, when this PG case came in 2019. So I think we are already in 6 years down the line. All of us know what it is. Anyone here would like me to do a short recap of what the personal insolvency is and then bankruptcy?
Yes, sir. Yes, sir. Please start with that.
You want that? Okay, fair
Yes.
enough. So let's do one thing. I'm sure all of you are already doing PG cases, but at times what happens is theory is not touched upon a lot of time. Uh, when was the last amendment which happened in the PG cases, in the PG regulations? It happened in January 2024, almost 1 year, right? And that also was a very small amendment. Whereas CIRP every week we are changing, right? We are still changing CIRP every. So PG cases had taken a back seat in our scheme of things. Uh, the COC voting right is still 75% to pass a repayment plan, which was the time when we had CIRP time, and that changed to 66 long back, but PG we still are holding on to that. And same goes for bankruptcy. Our regulations in PG, how many pages are there in the PG regulations? Anyone? How many pages? Anyone would like to tell me how many pages are there in the PG regulations? Number of pages. CIRP, there is 100, right? 101, 100, I think. No? In bankruptcy as well as PG, the regulations are only 13 pages, 1 3, out of which 3 will go into our, what do you call, forms, form A, B, C, and some definitions, and we are left with 7 to 8, regular pages of regulation, 40, I think, 40, 42. So considering that this is supposed to be an easy topic today, not too much of hassle. We will just learn how to, manage them. And that is one side which bankers also think that these are easy cases. Then, why should you get that 1 lakh and 2 lakh like how you get in CIRP cases? So here, even the fees is also accordingly. So let me try and touch upon which chapter it starts with. Anyone would like to share? 79 is which chapter? No talks, all are mute, man. So I hope it's not going to be a one-way story because CPRs are easy, I can understand.
Rana ji, please don't humiliate us by this.
No, no, sir, it's not humiliation. It's only
ये तो टीचर को याद होता है, बाकी तो सब जो है देख देख के करते हैं प्रैक्टिस.
नहीं, सर आपकी
All
बात
of us
सही
are
है.
not teachers. You are
सर
guru.
सर कभी कभी ना बीच में if you ask questions, so I
हंसी
will also
मजाक
get
करने आप
motivated because it's
तंग
2:35.
करने के लिए
So
आप पूछ सकते हैं.
okay, so 79 is the section where it all starts. Fine. Why I'm saying these chapters are important, okay? Why I'm asking you this unnecessarily? You'll say why this question is coming up. In one of my when I was giving my IBB exams 8 years back, they asked a question whether NCLT has a president or a chairman. So NCLAT has chairman, whereas president is in NCLT. And I used to think, what kind of question is this? I mean, does it really matter also to in my life? But and why I'm asking this question, you also might feel that, why I'm asking this question. In a very recent case, Supreme Court has said that in PUFE, 43, 40, 50, 43, 45, 50 is in separate chapter, whereas 66 is in separate chapter. And since they are in separate chapters, NCLT has different powers to deal with both. And what power NCLT has in 43 doesn't have in 66. And that is why totally different, things we have to take care of. Which case is that? Anyone? Diwan housing,
Yes,
right?
Divan housing, yes.
So that is
That
why at times, these chapters are important, where they're located. Even that.
that is why Rana ji 13-page case law becomes 1,300 pages of case laws.
Yes, that
So
happens, sir.
such questions are asked, you know, which have a less bearing on the actual impact of the objective.
Correct, sir. So that is also one side of it, yes. But since it matters,
Uh,
we are now dealing with part 3 of the insolvency of this IBC code, which is insolvency resolution and bankruptcy for individual. So insolvency is always compared with CIRP, bankruptcy is always compared with liquidation. So 78 and 79 are announced. That means application of this part where it says provided central bank, it can only go up to maximum of 1 lakh rupees and not less than 1,000 rupees. So if you have a default of 1,000, you can initiate as per the code. Okay. What is as per NCLT that we will discuss, in our case laws, it might be different there. But the law says up starts with 1,000 and maximum we can make it 1 lakh. Like in CIRP, the minimum is 1 lakh and maximum we can make it 1 CR. Fine. 79 talks about your educating authority. Right now we know educating authority is supposed to be DRT, but since individuals have not started, right now every case is only going to NCLT. Has anyone knows we have started a PG to CD in DRT here? Any one of you would like to? Any experience or have you heard of? No, I also have not heard of. Okay, good. So few things are important in definitions. Let's learn the definition, and then I'll tell you how the process starts. There are reports, etc. Right? So educating authority is supposed to be DRT. If it is related to PG to CD, then NCLT wherever the uh, main application of the CD is pending. Fine. Associate of a person who belongs to immediate family, person who's a relative of the debtor or relative of spouse, person who's in partnership, associate, I believe all of you know, so I'll skip this part. Bankrupt means Now, bankrupt is a person who is adjudged as such. So he has to be declared bankrupt. Before declaring bankrupt by the court, you are not a bankrupt. So that's the only definition it says that it should be adjudged as such. Bankruptcy means state of bankruptcy. I guess all this is not really okay. In PG to CD and bankruptcy, we still call the committee as COC only. We do not call them stakeholder consultation committee. Stakeholder consultation committee is in liquidation of the CD. Whereas in PG to CD matters, we still call them COC, all of them. And here we do not have the differentiation between OC, FC, nothing like that. All are at same pedestal. Debtor includes a judgment debtor. Discharge is when the person is like how in CIRP happens that this person is out of the clutches of law. So same way discharge order can be under section 92, 119 and 138. 192 is not yet there. 119 and 138 is there. 119 is personal insolvency. 138 is bankruptcy. There are some excluded assets and same way excluded debts. Excluded assets are those assets which the person needs for his livelihood, because you are resolving a person. Resolving means we are not killing the person. We want this person to survive again. Whatever he has, let him offer and we let him go. So obviously he will need some assets which can still remain with him for his life. What are those? Like his unencumbered tools, books, vehicles, other equipments, etc. for his personal use or employment. Suppose he's a delivery guy on Zomato, you don't take away his vehicle. Very crude example, might not suit to a PG to CD, but his personal livelihood, if it depends on that car, don't take it away. Unencumbered furniture, household equipments, provisions as are necessary for satisfying the basic domestic needs of the bankrupt and immediate family. Now, it has to satisfy basic domestic need, okay? It should also not be, if it's a direct, he was, suppose the person was running say, a large conglomerate, don't expect this person to live in 10,000 per month. How will this person live in 10,000 per month? So this has to be a satisfy basic necessary domestic needs. Any encumbered personal ornament of such value, and that value is 1 lakh rupees as per our regulations. Any unencumbered life insurance policy, pension plans in his or his immediate family name. Now, because there is no mention of how much pension can be there, it can be anything. Right now, there is no criteria which is set that he can only have a 5 lakh policy or a 5 crore policy. Right now, that is not clear. An unencumbered single dwelling unit owned by the debtor of such value as may be prescribed, and that value you all know by now is 10 lakh and 20 lakhs. 10 lakh in the rural area, 20 lakh in the urban area. Fine. But it says unencumbered. If it is encumbered, then there is no need. Then we don't know where this person will go. But if it is unencumbered, then 10 lakh and 20 lakh we leave this person. Obviously,
Ranaji,
now,
can I
yes,
ask one question?
yes.
The two things. One, I wanted to mention that here, in the case of CRP, they call committee of creditors. But
Correct.
to my surprise, once we are written committee of creditors, then it was objected. They say it is only creditors, meeting of creditors. It is not committee of creditors.
Sir, please read this. Point number 11. What does it say?
It says committee of creditors, but it has been objected that call it a creditors. In the case of CRP, you will constitute a committee of creditors. In one of
Correct.
the cases, it was objected, and then we rectified.
Sir, I'm showing you the act. This is the updated act.
Yeah.
Section number 79, definition 11. 79 sub clause 11, committee of
So
credit.
I'm just saying the anomaly between the understanding of the NCLT and the actual act statement. And number two, as you said that livelihood, and I have an office where I run my practice, and I am a personal guarantor to the corporate debtor. So that office will
Correct.
be exempted. I
If it
depend
is,
upon that.
yes, sir. So that is why I'm saying this part is not touched upon, that what can be the limit of that. So
Uh,
you cannot come that this Mercedes is
no,
important for
not
my
Mercedes. My
livelihood.
office.
I'm
I
just
have an
giving an
office.
example, sir.
Yes,
So
yes.
if you have a office which has a sitting capacity of 2 people, let's say 3 people whom you work with, it's fine. You cannot say I have a full floor plate available in Bhikaji Kama place and I need this for my office.
But
So
my seat, my staff is to 20, 100. Where will they sit?
if your staff is 100, they would have made you enough money to repay the debt of the company, of the bank.
Well, I
So
do,
then let them
I
work
do,
harder and
I
make it.
do it. I do render services at very minimum cost, at 5% of profit.
And you have 40 staff.
I earn one crore. I spend 95 lakhs. My net income is 5 lakh.
Good. So then keep paying this 5 lakh for next 50 years to the bank.
Yeah, and
No
my
problem.
living standard is 4 lakh.
I know that is happening. Unluckily, what
Yeah.
you're saying is also right. What the law says right now, we are
So,
discussing that.
so
And
these are very big ambiguities. They a citizen of the country is entire. You cannot say because he is filthy rich or he is qualified, he is a professional, he should live a different life than a poor person, you know, who is a farmer, he should live a different life. There has to be equality in the eyes of law at least. Practically it is not happening, but in the eyes of law it has to be one. So let there be a fixed amount, fixed things, up to this value. These are the equipments which will be considered as a equipment for livelihood, whether it is office, whether it is
correct, correct.
motorcycle for Zomato driver, as you gave very right example, you know, and this is the income which you are entitled to claim for basic amenities. Depending upon the,
What
maybe you
Anilji
can
is
say
saying, what Anilji
uh,
is saying,
class A city,
maybe
class B
maybe
city,
correct because, but sir, only problem is when we are
otherwise it will lead to
resolving.
litigation.
Exactly. So
Otherwise it will lead to litigation.
if PG to CD was reported, you know the first case, right? That Lalit
Uh,
Kumar Jain case.
जी.
Everybody went to Supreme Court saying why only we are being sidelined, PG to CD. Why not everybody? Why only chapter 3 is being notified for PG to CD? This is discrimination and it should not have been done. So all that that's our life, sir. We live with it. But right now, what we are learning is
No, but this
excluded
will
debt.
all these are the causes of litigation. In one of my cases, the personal guarantor declared jewelry, personal jewelry of say, let me give you the exact number, 40 lakhs. And
Okay.
the lender did not look at it. They did not, they say it's a personal jewelry of 40 lakhs. He did not declare it for distribution. And the lenders did not look at it.
Sir, actually, this one is material when the bankruptcy starts.
No, even during PIP process. Uh,
No. So during PIRP, this is just a plan. There is no coercion. You
no, but
don't
he is
have to.
declaring in his assets that he has got jewelry, gold jewelry for his
Yes,
wife and mother worth
correct.
rupees 40 lakhs. And
Okay,
it is declared. Lenders are seeking details of assets, but they are not.
correct.
We are mentioning in the meeting that he has declared it. It is not looked
Okay.
at it. At some other places, even asset of 5 lakh is being looked at it. So these are the reasons for litigations.
That is commercial wisdom, sir, which
Yeah.
is unjusticiable. Almighty COC can do anything, so that we can't say much. Uh, but let's learn what excluded asset debts are. Assets, we know what are excluded assets. Debt is when there is a liability to pay fine imposed by a court or tribunal. Now, do you think NCDRC execution order should be covered in this excluded debt? We don't know. We'll
Except
we'll
only for
learn that today.
penalty.
Okay, so penalty means what? The
That is
order
that
of NCDRC is also sort of penalty, right?
no. If it is a principal amount plus interest, how it can be?
So,
If it
so
is
interest is the penalty, is it?
no, interest is for delayed. Penalty is different. Interest is different. Fine and penalties are different. Prosecution is different. Interest is the cost of the amount which you have not paid.
Okay, fair enough. So you are saying that is not covered.
That is
Okay, okay,
For
we'll learn that, sir.
penalty,
So
you cannot get exemption. Fine
penalty is not
penalties,
exempt,
huh,
correct?
any criminal offense.
Liability to pay damages for negligence, nuisance, or breach
Yes,
of a statutory contract. This is also there. Liability to maintenance to any other person. Any person can be your parents, can be wife, can be children. All this will be covered. Liability in relation to student loan is also not covered, and any other debt as may be prescribed. Firm, immediate family, partnership debt, qualifying debt, we all by now know. Here we call the resolution plan as repayment plan. Resolution professional, we all know. Here we don't have something called interim. There is no interim word here used. It is only resolution professional straight away. There is no process of confirming, non-confirming, section 22, section 27. Here, once appointed. The moment you want to change the person, you can change it. And who can change the RP? COC or the personal guarantor also? Personal guarantor also, whenever they want. They just have to file an application saying we don't like the face of this person, kindly change, and it will be done. No problem. Undischarged bankrupt who has not received the discharge order under 130. Now, this chapter 2 is not notified yet. So 80, 81, 82 is nowhere there. Nowhere. Okay. Now we come to straight away So chapter 1 was definitions. Chapter 3, now we are coming to part 3, chapter 3. Insolvency resolution process. 94, 95. 94 is when the person goes himself personally, either through advocate directly or through an RP. Both options are possible. That is section 94. Section 95, application is initiated by the banker or somebody who has taken the personal guarantee. Now, obviously, it has its condition that, last 12 months you should not have done this. Majority of partners should be agreeing. Now, right now, since this is not notified, so we are not touching it. Right now, this person has to be person, individual person. That is allowed. 95 filed by the banks against 1%, 2%, 3%. Whatever number of guarantors are there, you can file against each of them for the amount of default. Liability is simultaneous. You just invoke the guarantee. 15 days time. If it has elapsed after the notice, then it will not be counted. Now, anyone here who thinks that invocation of notice is as good as invocation of guarantee? I mean, sending of demand notice in this?
You have to specifically mention the guarantee is being invoked. Demanding
In the
money,
notice itself, sir?
then it will be considered as a invocation of personal guarantee. Otherwise, it will not be considered. If you
Any
send
other
demand
view?
notice only
Okay.
because the corporate debtor has defaulted and do not make a mention of your personal guarantee and which you are invoking, then it is not invocation because you are demanding. Corporate debtor has not paid.
Okay. So that failure of the debtor to pay the debt within 14 days of the service of notice of demand, you can file the application, correct? My only question was whether this sending of notice should be considered invocation also or not, which Anil Kumarji said, no, it is not. It should be separate. Any other view?
Yes, he's right. because it is already been held in Deepak Kumar Singhania in LML case by the Supreme Court on 20th Feb. Yesterday we have discussed this. Invocation must be
Okay.
made
Right, so-
separately, and thereafter demand notice should.
So you have discussed that, then it's perfect.
Yeah.
Okay.
Yeah.
So recently this, as you rightly said, the Singhania case, this has been held that invocation should be separately held. And it was again an SBI case where, we were challenging this.
And even in the demand notice, sir, we can mention about the invocation, that this to be taken, this to be treated as an invocation. Then it is treated. If we are simply demanding without stating the invocation of personal guarantee, then it is not to be taken.
Is this
Because
also correct?
Because limitation, the all these cases are stuck in the NCLT because of the limitation. And the limitation is being considered from the date the personal guarantee was invoked.
Invoked, correct.
That is the crux which we have, though case laws you can quote, but what we have experienced in different cases is that.
So we'll discuss this Deepak Singhania case also once more, if all of you know it very well, then I will ask one or two questions and please enlighten me. If not, then we will discuss it. I also have, because it's related to our invocation of guarantee. So I have kept, so today I'll be discussing 10 cases with you. Okay, one of them is obviously this. So if it is already covered, then 9 left, we will touch upon that. Okay. So 94, 95, you know which are the section. 94 self, 95 the bank takes you, 96 is your interim moratorium. This is not there in CIRP, it is here. This is on the date of filing of application, right? Initially it happened that, till the scrutiny is cleared or till the scrutiny is not clear, all those issues, but now it is on the date of filing, the interim moratorium starts. An interim moratorium is almost as good as the final moratorium. Final moratorium, so few things will add. Now, in your view, 94 should be easy to admit or 95? 94 is when the person says himself, I am not able, I am insolvent. That should be easy to admit, right? Nobody to challenge
Yes,
94.
yes.
You think that is easy, sir?
I think it is easy because I am dealing all the cases under section 95 only.
So that means 95 is not is easier, it seems.
Yes,
Then what you are saying is different.
Uh,
Then 94 should, if 94 was easy, then you'll have more cases of 94.
yes, 94 is easy. Yes.
नहीं sir, उल्टा बोल रहे हैं. You are saying 95 you are dealing with, correct?
Yes, 95 I'm dealing with. 95 is taking time because in that he is not accepting the liability, but in
Correct,
94 is initially is accepting liability and coming to the court.
Okay. Anybody here who is an advocate and has filed 94 or as an RP? Because see, 94 is like section 10.
Yes,
Correct?
94 is difficult, sir, because there you have there there is an allegation that he wants to avoid surface action, he wants to escape from the liability. But when a creditor files, then it is easier to get accepted.
So you are saying section 7 is easier and section 10 is difficult.
Section 10 is otherwise also in CRP, if you see, Section 10 is very difficult. You have to prepare a statement of affairs on the date of filing of the application. You have to prove that your business is not capable or viable to meet all the liabilities.
I agree with Anil Kumar ji. Yes, sir, you are right. One of my personal case, 2.5 years have gone by and 94 is still not admitted. And the person is enjoying interim moratorium anyways. So 94 is more difficult because then court has to check that why somebody is, coming himself and saying I'm insolvent. Even though the code says something different, That first instance, you come to the, protection of the insolvency court and declare yourself. But I think in practically, it's very different scenario. Uh, 94 is very akin to Section 10, which is, I think, very, very difficult to get admitted. Better you tell somebody to file against you and you don't put any, objection to it. That is much easier. So 95 comparatively is easier. That's personal experience. That other people might have separate experience also. My personal experience, 94 is more difficult to get admitted than 95. Okay, so 96, we know interim moratorium is there. No legal action, proceeding, surfacing, etc. will stop. 97 is when if the person is appointed, the RP is appointed. Otherwise, a new person from the panel is appointed if there is no disciplinary proceeding. This thing is done away. I think it's still mentioned, but practically we are not doing it within 7 days of receipt of direction, etc., etc. Now there is a panel, we get appointed on the 7 days. All this has no meaning. RP shall be provided a copy. These are procedure. Replacement. Now replacement is when the debtor or the creditor. Now there is a famous case, right? That Subhash Chandra ji case, right? Where uh, he had filed that, this person met me in Lodi Hotel, the RP, and that is why it should be changed. I mean, that was amazing reason which was given, and NCLT spent 10 pages just to say that fine, we are replacing. The court says straight away where the debtor or the creditor is of the opinion that uh, this person shall be replaced, he may apply for the replacement. That's all. And A shall within 7 days. Shall. There is no maybe, will be, yes be, ho be. Shall. Straight away shall. Within 7 days of the receipt of this application, change this person. So it's a very straightforward, anybody can. So that is why you can't force the PG. No
Ranaji,
coercion.
I here differ. The
Okay, what is the difference?
shell will not be that it has to be necessarily replaced.
Why, sir? What is the ambiguity in this?
Shell will not be, otherwise there will not be any stability in the continuation of the process. If in one process 3 times application is made and insolvency professional is replaced, the whole process will suffer, it will be delayed. So this also, uh, in many cases, it is being debated in the NCLT also, and there are applications filed by other people, and they are being considered. NCLT is not taking
So your voice is no more here.
that it has to be replaced.
So the code is very clear in my view. Uh, Again, as I said, see, everybody has own view because if everybody is agreeing with NCLT, then we don't need NCLAT. And if everybody agrees with NCLAT, we don't need high courts and Supreme Courts. Even in Supreme Court, we have review, revision, 3 times we go there. Correct. So views are different. These are views. As per me, the code is pretty clear. It straight away said shall, and it doesn't say shall be treated as maybe, and that interpretation is not being given. Normally, this interpretation is given by the constitutional courts. NCLTs do not have the power to decide on this. But fair enough. If you're saying that there are applications, let us see what kind of order comes. But in my view, sir, if that application is filed and is disposed of, they will not have an option but to replace the person. I personally don't know any case where the application was
Then
made.
then then the
This
applicant then why the applicant is giving any reason for replacement? Then he
no need of replacement, sir. They can say I don't like the face, then that's all.
should not give.
Where
He is being asked to give. He feels that the conduct of the RP will be biased. You know.
correct, sir. Correct. And that is and see, that is why we are trying to learn the basic right now that why this should be allowed and why this should not be allowed. This should be allowed because right now there is no force, there is no coercion. You are only assisting the PG in the personal. See, this option is not available at bankruptcy stage. Bankruptcy, this person cannot remove you. But in PG case, personal insolvency case, you are a friend to this person. You are a debt counselor to this person. And this person has the right to replace you. That 10, you know, Advocate Chaurasia was there with him. So one RP, one advocate met in Lodi Hotel. The blame was that this person is meeting me in 5 star. Socho Chandra Saab, right? Now it's a now RPs are not that poor also, right? We can afford a 5 star tea, right? How much it will be? 1,000 rupees. So this person said he is meeting me there. This cost will any which will be loaded in my personal insolvency. Remove this person. 10-page order, and the answer was yes, replace him. So that's what my view, personal view. I thought there is no need
Sir,
of 10-page reasoned
yes, sir,
order.
you have yourself answered that this is a mockery of the whole system.
It is a
That
mockery, sir.
for
It
all
is a-
such reasons, unless there is a justified reason for, and as such, I don't agree in the CRP process also, the right to replace is given to the COC. But in many cases, if the process has advanced, it is at the last stage, and you want to reverse the clock, what, and delay the process by replacing, it means in the PRP it can be replaced, then 4 times for any flimsy reason you will replace the RP. Sometimes creditor, sometimes debtor, sometimes banker. No, this is not done, na. There has
That's how
to
the
be,
law stands today, sir. So
there
we
has to
are
be some.
only
No, no, it's okay. We are discussing, debating. So
correct.
that is why I see many cases the reasons are being assigned for replacement. So the NCLT is
Correct.
convinced. Otherwise, why should they assign the reason? They should simply say, why should Mr. This Chandra say that because he is burdening PRP cost by meeting us in 5 star hotel, where there is no need. He should simply say, please remove him. I don't like his conduct. That's all. I don't want him.
That should be sufficient, yes.
Ha.
Uh,
If that is the case,
in fact, sir, one of the case, if you remember earlier when MM
and
Kumar
you have
Saab was
discussed this
there,
case before in your last one of the webinar. We
sir, when
discussed.
MM Kumar Saab was there, if you
Uh,
remember, he used to
yes.
say that why you need a reason. So
Uh,
there was an RP who objected. He said, what is the reason for my replacement?
uh.
So he said, why do you need a reason? They will say you are a chore, you are a, you know, bad person. Why you want them to blame you? So he said, they want you go, just go simple. What's wrong in that? If they want to give you reason, they will create 10 reasons to send you
Uh,
home.
Reason have to be substantiated, na. I
Sir,
can't.
again. So that's what he said. That's what, though he said in a, not in a very
Verbal arguments,
exactly. So he said, why you want them to give you reason? They'll give you 10
it
reasons.
may not be recorded
Forget
in the
it.
order. Yeah.
Exactly. They said they want you go, please go simple. Law is clear. And that's how that's why in my view said no need to fight. If they want you go any which ways it's happy. Oh, it's
No,
okay.
here I don't agree. Unless there is a sufficient reason, justified reason, the replacement, whosoever may be, I may be
Correct.
suffering in that
Fair,
case. If you suppose you are in a case and I can replace you. So it doesn't mean that I should, prevail upon. No.
fair enough, sir. We agree with you, sir.
Self-esteem of the profession is very important.
Okay. So section 99, we all know,
Section
very
98,
important
sir,
section.
Section 98, 1 second, sir.
Yes.
On Section 98, if the resolution professional is appointed by the proposed by the bank under Section 94, 5,
95.
then can the debtor come forward and say, no, replace this person?
Yes, sir. Why not? What's wrong? 98 1 says what? Where the debtor or the creditor is of the opinion that the RP appointed. Now, there is no need of who proposed, what proposed, right? Then 95 is long over. Now 97. 97 appointed by the A.
Oh, sir, why I am asking this question? because when the after appointment of the RP under section 97, he is supposed to give a report.
Correct.
Generally, the report is always skewed heavily against the debtor. Yeah, if I prepare a very neutral report, and if I definitely there will be some friction between the debtor and the resolution professional. In that case, debtor will come forward, will say, okay, just remove him, bring another
No,
person.
sir.
If another
Sir,
person
why,
comes,
why, why
sir, let
did
me
you?
complete. If another person comes, if another person does something, again he will come forward, because here it is not written how many times they will change. Again he will
No,
change.
yes, sir. That is what I was
So,
telling.
so what can you or me do here, sir? This is act.
No, we cannot do, but we are saying this is a serious
But
flaw.
yes, that is what case you are saying is correct. That is
Yeah.
possible. Why not? And I don't agree with the point, sir. You said it is highly skewed because RP is only presenting facts. Our
Yes,
report
that I'm telling you,
cannot be
highly.
skewed.
Sir, I am resolution professional in 7 cases. I have
Okay, sir.
already submitted my report. In
Correct.
all those reports,
Which report, sir? Which
definitely
report?
those people,
102,
99,
112,
99.
which one?
sir,
99, which one?
under 90 section 95, I have submitted report under section 99. In 7
You have only given section 99 report, right?
report. Okay, I
That's
am.
all.
That's all.
So
Till now,
99 make what is secured, sir? 99 is whether this person has made payment or not made payment. Whether limitation is there. There are only 10 points which you need to check in
yes,
99.
yes.
How can it be secured? That's my no. So I'm not able
No,
to
no, I
digest
have to.
this
No, no,
word.
no, 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 no,
No.
no, no. First of all, what you are telling that I have to give a report. Report means I have to describe everything from taking loan till now. What happened and how they have how the debtor has behaved. That is the report. What you are telling, just 10 points give whether default is there or not, or whether it is within the limitation or not. Not that we have to give report means I have to give detail.
Sir,
How
99 says what, sir? 99, I mean, if you are inviting, I mean, if you want to be writer, that is a separate thing. As an RP, our job is limited to section 90. See, I'm talking as an advocate here, right? As an RP, I want to be a writer, I can write 100-page report. What is the need of that? It simply says section 99 submission of report RP shall within 10 days. You have only 10 days. How much can you write in that? How much opinion can you put in this? It straight away says 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 compliances you put that this report was served, that is given or not. Story should be over. There is no need of putting your
then what is
opinion.
the
Where is the opinion,
requirement?
sir?
Then what is the requirement of this section 10 99 report?
That's what I'm
Because
informing you, sir.
that
Where it
whether
is.
that is default is there or not, it is already there by the IU report. That IU report says the default is there. There is no denial of default, and only thing is that limitation, whether it is under with limitation or not. Bus.
Correct, sir. Itna sahi hai. Your role is only that much. Please don't become adjudicating authority. Try to understand your role in this. Your role is very clear. Supreme Court and simply has said 99 is only recommendatory. It has no other value. There is no use of giving notice also to the other person. And that is what they said. Adjudication happens, admission
No,
happen after this.
NCLT, sir, NCLT says whether you have given notice to that to the
Yes.
debtor or not.
Yes, which
If
is here in 99. Yes. Okay. What else they ask you? Tell me.
what they asked me, whether you have given report to the other party or not.
Correct, which is
They
here.
are then
Okay.
section 9, they have to challenge the section 99 report. They are challenging. The section
After that,
99
no, sir.
report.
After you submit 99, they will challenge, obviously.
Ah,
Otherwise, how will you file it, isn't it? So they will, I'm only saying,
when I am preparing the section 99 report,
yes,
then I submit a IA. When I submit
correct.
a IA, definitely I have to give a
Proof of service.
copy to that
Correct.
person. But
Correct,
before
correct.
there, NCLT says, have you contacted that person? If that person is not there, if you have not contacted, if you have not taken any facts from him, then
Correct.
how could you prepare the report?
Yes, you cannot. You are right. They are right. If you have not contacted, if you have not attempted to contact, how can you prepare a report? That's what it
Ranaji,
says. No, sir, please read
Sir,
section.
just now,
No, Ranaji.
you are telling that two things to be looked into. First thing is that whether default is there
Did
or
I
not.
said that
Second
don't
thing,
contact this
limitation.
person?
It is there already on the record. It is in front of. Still, NCLT says you have not given any reasonable chance to the other party before preparing your report.
Correct,
Ranaji,
sir. That is why you have 10 days. No, that's what we are discussing.
no,
In 10 days, you mail them that this application has been referred. What are you saying? That person, if it tells you, you have to mention in your report that according to the creditor,
That is the
according to the
story I
pay.
have. That is I'm telling. That is the story I have to mention. That is the story. What
Correct,
he
sir.
is
So
telling. Suppose
why
he
does that?
tells something. I have not taken loan. That is the story. That you are telling. I'm a writer, not writer.
No, Jana
Ah.
Sahab, I did not say don't write his side. I'm
No,
only saying
your comment was very derogatory. That you tell it is a writer, not writer, sir.
Ranaji,
okay,
to
GNL.
sum up, let me request what Jenaji is saying, and it's a question of interpretation. You said that RP is not an adjudicating authority, but
Correct.
NCLT is taking decision based on the
Based on.
recommendation. If
Correct.
recommendation of the RP have to be supported by the facts and documents. See, you have rightly mentioned
Correct.
that on 10 points he has to comment. And for commenting on 10 points, he has to do some investigation work. So
Correct. Correct.
particularly two things are very important. One is limitation. And to unless you sincerely investigate and deep dive, you know, invocation is not easy to this limitation is not easy to deal with.
Correct, sir.
Limitation is debated there, and personal guarantor and other people come and challenge your 99 report. There, if you have recommended commencement of PRP without getting into details of the limitation, because I have faced this.
Correct. Yes.
There, NCLT will come again, will be very angry with you, will be furious with you, because
Sir,
it was your responsibility. And number two, as Jainaji was saying, if you do not contact properly, and he has already paid the money, he has submitted a settlement, and you have not mentioned, so you have to mention the facts and what from the date of application till now, what all has happened. At the
sir,
time of
will I?
application, there was a default, but at the
Correct.
time of submission of 99 report, whether that
Absolutely.
default has been rectified, maybe he has rectified, it is settled.
Obviously, sir, you have to. Why will I say
So,
no?
so
No to this.
my submission
Hmm.
is, it is
Hmm.
not legal. He is not doing adjudication, but he is
Correct.
helping the adjudicating authority to take a decision.
Absolutely.
And
Absolutely, sir.
for that, today only we heard Adil Goyalji one case in Enclave where they said
Yes.
10 days is also not mandatory. They are recommendatory.
Absolutely.
You,
Absolutely, sir.
if you can do justice with your report, and there are reasons because you have not gotten the reply from the debtor.
That case also I'll discuss, sir, in
Yes,
the
sir.
end of
So
my
let us
session
sum
today.
up and move forward.
Yes.
Both of you are right, sir. You know, and
Jaina ji got offended,
no,
sir.
no, no,
That word
you have
was not to
no,
demean anyone, Jaina sahab.
no, not at all, not at all.
My only comment was, as
Yeah,
RP, our role is limited. Do the
yeah.
investigation, contact them, whatever the facts, as an officer of the court,
But that
report it.
but
That's
that
all.
limited role is very important, sir. What I want to very
Certainly,
important,
sir.
and it helps It helps the adjudicating authority. Other, if you do not do justice, you face
Yes.
lot of consequences there. You
Correct.
know, in our case, you are involved in so many cases where NCLT was not happy with the report. You know,
Yes, yes, sir. In the
we had to
beginning, and
file
now
we had to file additional affidavit because at that time it was beginning of the PRP, and we had not
absolutely.
dealt with in detail about the limitation. You know,
Sir, unluckily, 99, if you see, it doesn't say that. It still doesn't say.
ah,
In
and
this, it still
that
doesn't
is being
say.
debated in one of the
Exactly.
cases. In one of the
Yes,
cases, the opponent, the personal guarantor, has said that RP has no right to dig into limitation. Then
exactly.
we said that how I will recommend the commencement of PRP if it is not covered within the limitation. So I cannot comment, I cannot recommend even if I have not checked the limitation. So it's a,
Correct.
though it does not say, but to my assessment, and you are a senior advocate, you can say that otherwise my recommendation has no meaning if I have not done the justice.
Correct. Correct. So I guess with this, we'll move
That's what
little
I think.
further.
And from the access. Yeah.
बिल्कुल sir, बिल्कुल. So 100 is admission rejection. If it is rejection, no problem. If the admission is done, we go to the that publication, etc., etc. Right now, the moratorium starts. 101, 102 is your notice and claims from the creditors. Or maybe when Anilji was saying that they are using the word creditor is maybe because of this, not committee of creditors. But if you see, you issue a notice, details of the admission, resolution, notice shall be published same way like CIRP, vernacular, one English, one, they also say website of the AA, which normally is not possible. Registering the claims by creditors. Creditors shall register their claim with RP. There is only one form, which is Form B, which is supplied and can be supplied courier, speed post, etc., etc. All other information which may be asked by the RP. Preparing list of creditors. RP shall prepare list of creditors based on information, claims received. RP shall prepare this list within 30 days. In CIRP, this has to be done within 14 days. Here we get 30 days time to do this. Now, a repayment plan. 105 is the repayment plan. So 102 report. 102 is your publication. 106 we will go to report. 105 is only about what is repayment plan. Now repayment plan is how this person wish to restructure his debts. Now, a report of resolution plan on the repayment plan. So, first report we gave in 99, second report is 106. 106 is within 20, now it says 106 should be within 21 days of the last date of submission of claims. The report referred shall include repayment plan, whether it has a reasonable prospects of being approved or not, whether there is a necessity for summoning the creditors, a meeting or not. Now, obviously, this has changed. Now we know that even if no plan has come, you better call a COC and tell them that there is no plan which has come. Earlier days, there was no need of this. We used to straight away file that this can be closed. This was 106. You give your report on whether this plan will be accepted, not accepted. Though I do personally don't think this is a great idea. How do we know whether it has a reasonable prospect of being approved and implemented? Unless it is totally absurd or totally bad. So, but yes, this is one of the report which we submit under 102. After we have submitted the report to the court. We give 14 days notice, not more than 28 days notice to the CUC. So first meeting shall not be held before less than 14 days notice. So 14 to 28 days. In CIRP, we have 7 days time, correct? Here we have 14 and 28 days. Now, summoning of meeting, RP shall issue a notice calling the meeting of the creditors at least 14 days. What else you need to do? So in the meeting, you can discuss your repayment plan, statement of affairs, said reports, proxy voting, etc., etc. Conduct of meeting of creditors.
Now here also, Savanaji, there is one issue. Now
Committee
meeting
is,
has to be called
yeah.
after submission of the repayment plan, before submitting the report to NCLT, or we have to take direction from NCLT to call the meeting.
No need to take direction from the educating authority to call the meetings. Where does it say that you need a approval for that? It's only your report where RP shall consider whether you want to call the or not. See, actually, a report referred shall include that there is a necessity for summoning.
Yeah.
If
So
required,
if
it is your
required,
opinion as
Hmm.
RP, it is RP's opinion to decide whether you are calling. But NCLT, sorry, IBBI regulations says you have to call the COC meeting.
no, what best practices we are following. In most of
Yes,
the cases, we have been advised by uh, legal advocates like you only that
sir.
we submit our report on repayment plan to
Okay,
Honorable NCLT, and
okay.
there we say, for the reason explained, since the haircut is very high or the repayment plan is not should not be acceptable, please allow us, give us the liberty to call the COC meeting. We feel the meeting should be called. And NCLT has been kind enough to accept that and say, okay, we give you permission to call the meeting. This
So
has
you
happened.
you are saying without approval of A, you are not calling the meeting.
Yeah, we are informing them, justifying the reason for the meeting, and then we are calling the meeting. And we are giving them time also. The meeting will be called within, because there are some contradiction from which date to which date. You know, 14 days will
Sir,
be counted from which
suppose
date.
your application is not listed, let's say for 2 months, you
Yeah,
will wait. You will
yes,
wait till then.
we have done that. We have done this. We
Okay,
have done in
maybe
most,
that is one
we
way
have
of
done
handling it, sir.
in the most of the cases, we have done, and it has been as per the advice of uh, legal friends like you know, senior advocates like you.
Okay, so others are also doing similar
So
thing.
we want you to
If
clarify,
somebody would like to,
sir. You
sir,
can
let's hear
clarify,
it
sir.
from
What is the,
somebody
should we do
who
like
is.
this? So this was being
I,
objected, one of the creditors, you know.
I'm agreeing with you, sir.
Yeah.
Anybody else here who is saying we are taking COC's, sorry, A's approval before conducting the meeting? Maybe Jana ji or somebody would like to say.
It was
Are we
objected,
support?
sir. It was objected, one of the creditors, but we
Sir,
convinced them.
I heard you, sir. Let's hear it from somebody else. I got what you said. Are others also doing the same thing? I'm just trying to understand that. Anybody would like to share their experience there? Nobody? People have not handled cases or they are not wishing to participate.
No, my cases are just admitted on the basis of RP
Oh,
report. So we are about to
okay, you are at
conducting.
the beginning of it, sir.
Yes, yes.
Okay, okay, okay. Fair enough, fair enough. Sir, so views can be different. Somehow my view is law says you need a COC meeting to be done. Now, there is nothing wrong in calling a COC meeting where we are discussing the plan. And as you know, in CIRP also, things have started. They say don't wait for appointment of AR. Then now there is a interim representative has come up, right? Because of this opinion, difference of opinion that whether we should call a COC with AR before his appointment or with the majority, if we are saying then let's call the meeting. I was of the opinion that yes, we can. There were many RPs who used to wait for AR appointment and take a call. So obviously, as you know, as an RP, it's your decision. You can take a call. Somehow, I feel there is no use of waiting for 2 3 months just to ask the NCLT that should I do the vote, call the meeting or not. Reason, my reason, when COC's commercial wisdom is so unjusticiable in so many cases when Supreme Court has already held it, why will NCLT have an objection in having a meeting of creditors? So since they will not have an objection, I think, in my view, sir, Anilji, I might be bit differ on this, that there is no permission which may be sought. But yes, we give a perfect reason that this is the reason we are calling, and there is a chance or not chance that we don't know that can be discussed in the COC meeting. In 3 of the matters, I have recently done that, and COC has no objection to that. And the claim admitted is around 1200 crores and 850 crores on those matters. I guess NCLT will never say no to that, why are you doing a COC meeting? So that was 106 report. 107, I believe we summoned the meeting, 14 days, 28 days. Quorum, there is no mention of quorum here, but 33% normally we take it. When 33% people are there, you declare the meeting as quorate. Voting can be done by proxy voting, etc., raise of hands. Uh, Best idea is to get the electronic voting done. Conduct of meeting, provision shall 109, 10, 11. All these adjournment should be done or not, that is given here. At one time, you should not adjourn it more than 7 days 7 days at a time. And if there are sufficient reason, then only you adjourn. Voting rights in the meeting of creditor. A creditor shall be entitled to vote at every meeting of the creditors in respect of the repayment plan in accordance with the voting share assigned, same as the IRP, shall determine the voting share as per specified by the board, and board does not discriminate between OC, FC. All will vote as long as they are not a related party. Creditor shall not be entitled to vote for an unliquidated amount. A creditor shall not be entitled in the meeting if he is not a creditor in the list of 104 or if is an associate of that. Same way, like in liquidation, we have that option of the person not participating if it is an secured credit. Here, right of secured creditors are also there. Secured creditor shall be entitled to participate and vote in the meeting. Secured creditor participating in the meeting and voting shall forfeit his right to enforce the security during the period of repayment plan. During the period of repayment plan. Okay. Where a secured creditor does not forfeit his right to enforce security, he shall submit an affidavit to the RP that the right to vote is only in respect of the unsecured debt and estimated value of the unsecured part. So if you hold a security, you don't want to relinquish, you have an option to keep it out. You'll say, I have exclusive right, I don't want to get part of it. In case a secured creditor participates in the voting by submitting an affidavit that these are separate parts, so both the parts will be treated separately. Concurrence of secured creditors shall be obtained. Concurrence of the secured creditor shall be obtained if it does not participate in the voting of the repayment plan, but provision of the repayment plan affects his right to enforce the security. These things normally happen when land belongs to somebody, house belongs to somebody, right? So those kind of situations. One of you may please keep it mute.
ITC କିଛି ଅଛି ଆଜି ତ ଆମେ ଆସିବ 14 ତାରିଖ ପରେ ଆସିବ ଯେ ହଁ 14 ତାରିଖ ପରେ କହିଲି 14 ତାରିଖ ଦେଖିବ ନା ଦେଖି ମତେ ଜଣେଇବେ
म्यूट कर दीजिए सबको।
Sanjit Saab, please mute. Okay. I'll mute. Okay. Now, 111 is where the approval of repayment plan by creditor comes into picture. Here they'll say yes, no, whatever. Whatever they say, we file another report. This is the third report we filed here. Report of meeting of creditors on the repayment plan. RP shall prepare this meeting. Same thing, whether we say approved or rejected. If approved, and if there is any modification, that also shall be filed with the NCA. Resolutions which are proposed, list of creditors who are present, represented, etc., and any other information the RP thinks appropriate to be made known to the AA. This also. So here you have a liberty. This section allows you, you can give any information. Notice of decision taken at the meeting of creditors. Resolution professional shall provide a copy of the report of the meeting of creditors prepared under section 199 to the debtor, creditor, and the AA. So this is, I don't know why 113 we are talking about 99. In my view, it should be 112. This report should have been mentioned. I think the act is, this should be 122. So you inform everything. Whatever is happening is in the open. Order of A shall by an order approve or reject the repayment plan on the basis of the report of the meeting submitted by the RP. Now, okay, first let me finish this 114 and then we'll come back to the discussion. Provided that where a meeting of creditor is not summoned, the AA shall pass an order on the basis of the report prepared by the RP in under section 106. So if no meeting is required, then obviously the only report the AA has is 106. If they have only 106, they'll take a decision on 106. If subsequent meeting has happened, then obviously they will take decision on the subsequent report, which is under 112. Order of the AA approving repayment plan may also provide direction, like in implementation of CIRP plan we have, where AA is of the opinion that the repayment plan requires modification, it may direct the RP to reconvene and consider it again. That is always available, right? So 106, yes or no, you decide. Most of the cases, sir, IBBI say you'd go for the meeting, so you should go for the meeting. After meeting, you prepare a report, 112, submit for A, 114 will be the order. 115, effects of the order will be, it will be as if the debtor himself has given this plan. Right? It's not that it is forced or somebody has made him do it. It will take effect as if proposed by the debtor in the meeting. It's binding on the creditors mentioned in the plan. So if there is a creditor who's not mentioned, will it be binding? The answer is no. It will not be binding. Fine. And that is why if somebody is not submitting claim, doesn't mean their claim goes off. It's not like CIRP. There is no 32A section here, which is clean slate principle, or Ghanshyam Mishra case is not applicable in this case. If they have not filed it, you are supposed to deal with the person, not the RP. I mean, the debtor has to deal. This person was aware how much I owe to the person or not. Now, where the A rejects the plan, the debtor or the creditor shall be entitled to file application for bankruptcy, which is section 121, 22, 23, that we can go for.
Now, there are two questions, sir.
Yes.
Can I ask now or you want?
Yes, please.
So
Yes.
there are two things. One is when the report under section 112 is submitted
Yes, sir.
and the resolution plan, repayment plan has been approved by say 99% or 97%.
Okay.
And they have voted and we are presenting along with the report summary of resolution records stating the all list of creditors who have approved the plan.
Correct, sir.
Still, should the adjudicating authority ask for notice to be served again and ask the presence of the creditors in the next hearing?
Creditors.
Yeah. The creditors have approved the repayment plan with 97.76%. We are giving the list of creditors who have voted for the plan. And it is after several rounds of the discussion, meetings, okay, with the creditors. That still NCLT is saying, so, and the report has been served to creditors also.
Okay.
NCLT thinks serve the notice and call them in the next meeting, hearing.
I don't know, sir. Court doesn't talk any such thing.
Now you
Otherwise,
see,
in every
you are saying the
CIRP, then you
law.
should call the
You are saying the
COC.
law. We tried to convince NCLT, my lord, this has been already approved. We have already called several meetings of the creditors. There is a resolution approved.
Yes, and when COC is approving, what is the problem?
This
So,
is give them the notice and let them come for hearing in the next. So now another question. They say AA can reject the plan.
Yes.
Without justifying any reason. A plan
No,
has
no.
been approved by creditors with majority. Can A reject it?
No, sir.
So you're
Definitely
saying
not.
if he rejects the plan, right now you
No,
said.
if they reject the plan, then you have NCLAT, obviously, and
So why should
uh,
when we say the commercial wisdom of the creditors, if the plan has been approved by the creditors with majority,
and you're
and
saying
then NCLT is
97%,
rejecting the plan.
97% तो 12A करा देते हैं, sir. So
No,
this
no,
is just a
no,
plan.
12A is
I'm just
can
saying 90 with
NCLT, can
97 you can
NCLT
close it.
or can NCLT, should NCLT reject the plan which is approved by the creditors
In my view, no,
without
sir.
justifying the reason?
In my view, no.
Then it is you right now taught us the law says so.
No, sir. I never said that they
Huh?
can do it without any reason,
No,
sir.
where is the reason? It is not stated that they can reject and they have to justify the reason. They say it can reject the plan.
Sir, any decision, any order, I mean, this is Catena of judgment. It says every order has to be a reasoned order.
So
If
that is
the
okay,
order
but
is
when
not
the plan,
reasoned, if
the particular
their
law
order
should
is
say,
not
na,
reasoned,
particular when, under what circumstances the A can reject the plan. If the plan has already been approved and
oh yes, yes,
it is found as per the provision of IBC
yes,
and
yes, yes,
not against the law of the nation, and there is
correct,
nothing contrary, then it should approve. If there is any deficiency, see, like our appointment, we say
correct,
he is a member of IBBI, there is no
correct,
proceeding against him, that declaration is being given, and then he
correct,
says, okay, he can be appointed. So if any deficiency is found, he can reject the appointment. Understandable, you know.
right.
But here it is saying that he can reject the plan.
No, they can reject, sir, but not without reason. So every
So,
order has to be reasoned order,
so
right?
that is okay, but I don't.
So
Reason means even if it is, it doesn't say that even if it is approved by creditors, then also it can reject. What is it?
Sir, the act does not say that. Yes, you're
Then
right. Act does not say.
then
Only the Supreme Court is saying every time.
the whole process has gone for fix. The whole process,
Yes,
when the plan has been approved, NCLT saying call the meeting of the, serve the notice and call them here. He wants to hear from every creditor. He wants to hear from Kotak Bank and other PNB whether you have given. Now tell me, those who have given the consent, will they object now? Then NCLT say, if you are objecting, why did you approve, give vote? Unnecessary. What are we
I
doing?
don't know, sir. In my view, here there is no meaning because A doesn't have to become RP. If they have to become RP, then
So,
why they are judges. So,
so,
yeah,
so
this is the
different
domain of
NCLT, different
RP.
practices. Different NCLT. I think
Yeah.
you should conduct classes for NCLT members.
They are my lords. They know better what they're doing. The case you are saying, I don't know why things like that is happening. And I mean, unless there is a very, very big stark difference, maybe they are approving 0.01% of, say 1,000 crore is there and is offering 1 lakh and 97% people are saying yes to it. Suppose it is undigestible to them. then, they may ask for, otherwise there is no reason of,
Then the fellow has only 1 lakh, so what he do?
correct, sir. That is why they are only calling them, just to, be ensured that, they are not taken for a ride. That's all. Otherwise, in the law, there is no such thing that, they have to call. Otherwise, they will become RP. What RP is doing if they have to meet every COC member? So, I think this might be a peculiar case, but
No, sir,
that-
in our experience says that NCLT members also need to be given a training by either by the IBBI through advocates like you. So how should you look at certain things? Because different NCLT, different practices, different interpretation.
yes, that is there, sir. So we will learn when we are coming to, in very soon we'll this part is over, PG case is over. We will be coming to our case studies. Sorry, case laws. Now case laws, some of them have been covered yesterday, but I will cover them little fast, so that we'll cover up all our 10 cases. Uh, so completion of repayment plan, we know once it is done, you apply to the court and this person will be discharged. Repayment plan coming to end prematurely,
Someone
just
has
like
mentioned,
our resolution
as
plan failed.
Rajanji refer section 114, A shall be by an order approve reject the payment plan on the basis of report of the meeting of the case.
Correct.
So if the
So
report is positive, it will accept. If
it
the
will
report is
accept, yes.
negative, it is reject.
And it says shall, sir. It doesn't say may. It
Hmm.
normally says that, sorry, 114 you said. So order is, they can give direction if they want, say yes or no. Normally, sir, I don't know why NCLT will need to get into it. As long as we say no, Mia Bibi Raji. So when COC is ready, the person is ready, why will third person will have an objection to it? So
Hmm.
there's no reason for that disconnect. 118 is closure. 119 is our discharge of the discharge order. Discharge means this person can be sent early. Now this on completion or early discharge, if it is done. So hardly anything. 119 is the discharge order. 120 is our standard of conduct. Standard of conduct again dealt by 208. That we should act fairly, no reasonable remuneration, all that thing is there. One thing which has changed a bit, which I hope all of us know, now the same RP can be appointed for the CIRP as well as for the CD also, for the PG also. So earlier we had a limitation that same person cannot be appointed. Now that same person can be appointed also, even if you had acted as a RP of the CD. That is allowed. And once this is, so if it is successful, if the repayment plan is successful, then obviously there is no meaning of going for bankruptcy. But if there is no success, then you go for bankruptcy. This should be started within 90 days. 90 days within a period of 3 months. You have to go within a 3 months. Anybody can go. The person himself can go, the PG, or the bank can go. Whoever wants to go, but there is 90 days period. If the 90-day period is elapsed, then we'll have to start the personal insolvency again. That is what the bankruptcy thing starts. Here, the RP will be called bankruptcy trustee. COC will be called COC. Now, in our entire bankruptcy thing, there is no such thing called repayment plan. Correct? Anyone dealing with bankruptcy process here?
Sir, we have not yet started BT processes.
Okay. Anyone here who is a BT?
We have only theoretical knowledge.
Okay. Okay. I am bankruptcy trustee in one of the matters, sir, for last 1 year. Now 1 year is about to be over. In bank, and it's a claim of around 870 crores. The plan is approximately 4 to 5 crore only. Now in bankruptcy, I'm trying to propose a repayment plan. Now, there is no such thing exist in our code. It's only as a bankruptcy trustee with COC, we are discussing, we are trying to settle this thing. Now, you will ask me where do we have, uh, repayment plan in bankruptcy process? There is no such thing. I am considering that if the repayment plan is done, it will be akin to 137, which is completion of administration. Now, we don't know whether it will be successful, it will be passed. If 75% of the COC is saying yes to it, I will be putting it to NCLT Hyderabad. Let us say if this allow us, it may be another case law for you to learn. But bankruptcy is actually selling the assets. Creditors, 1 year you have to let this person go under section 138 on the expiry of within 1 year. Now, in 1 year also, NCLT 3, Bachchuji's Adalat was saying that this person cannot come, only a BT will come. Now, what if BT doesn't come and ask for a discharge? Then this person will be stuck, and then this section 138 will again be challenged in NCLAT. But we are yet to start there because bankrupt, as we just heard, right now, many applications are at the stage of 99 or at the stage of 112. So we are still, finalizing the repayment plans in most of the cases. Very few bankruptcies have started as yet. So that we will see how that comes to. With this, I guess theory part is enough. You know, Otherwise, it will be all theory. We have already spent 1.5 hours. Now, 1.5 hours, I would like to take you to the. Anyone wants break of 5 minutes? Then we can start our case laws. How can we?
You can take some break.
Okay, then let's take a bio break of 5 minutes.
Yes, sir. Yes.
5-7 minutes. 4:10 we will meet up and
Okay.
we'll cover up our 10 cases, 10 important cases related to PG things.
Okay. Thank you.
Okay. See. Okay, I guess we are back. It's been 10 minutes. People are back. Can we start? Please say yes, no, someone.
Yes, sir. Yes, sir.
We can start. Okay, let's do this. So these are 10 case laws which I have brought in. Some little old one, some are absolutely new one. Some maybe you have discussed it yesterday. Whatever you have discussed it yesterday, just tell me and we will skip that. First one was the most famous case of personal guarantors, Lalit Kumar Jain. Almost everybody had approached Honorable Supreme Court saying why only we are being sidelined and why we are being identified, etc. This was the matter in 2021, and after that only all the PG cases had started. So 19 till 21, there was hardly any thing which moved because NCLTs were not taking decisions till the pendency in Supreme Court was there. Now in this case, what has happened was it was whether upon acceptance of the resolution plan as the CD is discharged from his liability, the personal guarantor whose liability is co-extensive with the principal debtor is also discharged. So question was, if the debt itself is finished as per the resolution plan, then where is the question of guarantee? Similar thing had happened in what you call SBI versus Athena also, right? So but there can be hundreds of cases, right? Now we will only learn so that we can remember these names also. Some of these, whenever we are discussing with clients, etc. Lalit Kumar Jain case, question was if the liability of CD is extinguished, whether the liability of PG is still there or not. Fine. This was the question. In this case, relevant provisions of Indian Contract Acts were discussed. Section 128, surety's liability. Surety liability is always co-extensive with the principal debtor. Then continuing guarantee, revocation of continuing guarantee, whether it can be done, how it can be done. This was discussed. Revocation of by surety's death. That was discussed. Discharge of now, section 133 and 134 was discussed little in detail, where it said discharge of surety by variance in terms of contract, not variance also, 134. So, discharge of surety by release of the principal debtor. So, principal debtor is now with somebody else. Some new resolution applicant has come. They say the surety is discharged by any contract between the creditor and the principal debtor by which principal debtor is released by an act or omission of the creditor, the legal consequence of which is discharge of the principal debtor. So I hope this point is clear. If it's not clear, please ask me if any one of you have doubt. So 134 of Indian Contract Act simply says if the principal debtor is discharged, then by the creditor, then the PG will also be discharged. But it does not say that it should be, it only says about voluntary or involuntary, correct? Now that voluntary and involuntary then comes into picture, which was explained by the court. Right of surety on payment or performance, this is that subrogation right, correct? When a guaranteed debt has become due or default is happening, the surety upon payment or performance of all that, whatever he has done, he will get into the shoes of the person, of the creditor. That subrogation is also not allowed in our case, as far as the CD is concerned so far. Surety is right. This is not important. 141 we can leave. Observation by Supreme Court in this case were, again, the similar case was with Vijay Kumar Jain. For allowing directors to participate in the COC meeting is that the director's liability as PG persist against the creditor And an approved resolution plan can only lead to a revision of amount or exposure, or amount or exposure. Any recourse under Section 133 to discharge the liability on account of variance in terms of the contract without his or her consent stands negated in so and so case where it was observed. Language is approved plan is binding on the grantor to avoid any attempt to escape liability. So, I mean, obviously, it was a very large, judgment. We are trying to find some relevant sections out of it. Relevant one was the sanction of a resolution plan and finality imparted by Section 31 does not per se operate as a discharge of the guarantor's liability, since this was an involuntary act on part of the creditor. Creditor, even if, because this is by operation of law, this is not a OTS. This is not an OTS which was agreed by the bank and then it was discharged. It's an IBC proceeding. Since it is IBC proceedings, involuntary act, then the personal guarantor will not be discharged. That was primary thing which was held. Uh, Rest, I don't think is too important because since we have only 1.5 hours left, I'll straight away come to, case matter decisions. And if you need to discuss something, you can please stop me and we can do it. It is held that approval of a resolution plan does not ipso facto discharge a personal guarantor of a CD of his or her liability under the contract of guarantee. As held by this court, the release or discharge of a principal borrower from the debt owed by it to its creditor by an involuntary process, that is, by operation of law due to liquidation or insolvency, does not absolve the surety or the guarantor for his or her liability. Because contract of guarantee is always considered a independent contract. It is considered as per Indian Contract Act. It is an independent contract, though it arises from the same, debt. But it is a contract of guarantee. If invoked properly, the liability is coextensive. And even if that liability of principal person has gone away, there is no problem. Creditors can still go after them. This was held in 2021, Lalit Kumar Jain's case, Supreme Court. Second big case, this also we are aware, Dilip Jiwarjika, name of the case. This has been decided in November 23. Actually, this is the case when, so this is what we call the second round of litigation, okay, which happened in Supreme Court. In this also, I think there were more than 300, writ petitions which were filed for the PG cases, against the PG cases. In this case, D.Y. Chandrachudji, Justice Pardiwala and Manoj Mishra, this constitution bench gave a detailed order. That order, I believe people must have gone through. Here the question was, main question when it relates to PG was whether the report submitted by RP under section 99 is recommendatory in nature or binding upon. What is the role of RP? Is it facilitative or adjudicatory? At what stage the principle of natural justice be observed? So three answers we tried to give in this judgment. So answer was no judicial adjudication is involved at the stages envisaged between 95 to 99. So till court is under 99, there is no adjudication happening. It's a simple process, 94, 95. You have filed application. NCLT just had to appoint an RP and ask them, just check it. It's like, court receiver, you're sending somebody to check the premise. That's all. Just to say whether, yes, this person exists, does not exist, he has made payment, not payment, that kind of information as per Honorable Supreme Court. That is the decision. Now, RP appointed under Section 97 serve as facilitative role of collating all the facts relevant to the examination. This is the only role this person has. Report to be submitted to the AA is recommendatory, and obviously, NCLT has an option either to accept or reject. Now, submission that a hearing should be conducted by the AA for the purpose of determining whether jurisdictional facts are there, not there at the stage of 94, 95, 96. They said no such adjudicatory function is contemplated, and all this is all this option is available at 100. Till 99, there is no need to get into whether DRT has jurisdiction or NCLT has. Though Supreme Court said that there are cases where NCLTs are still saying no because of the jurisdictional fact. That case also we will cover, I think, 8th case in NCLT Kolkata. That also we will learn. So till 99, no adjudication. So no hanan of your, natural justice rights. That was held. RP may exercise the power vested under 99 for the purpose of examining the application and to seek, they just have to see there is no violation of natural justice till 100. At 100, if the opportunity is not given to the PG, then there might be a problem. That is not the problem anyways. No judicial, this we have learned that RP is only recommendatory in nature and hence does not bind the AA when it exercises jurisdiction. So this was held in Dilip Jiwarjika 2000. When was the case? 2023 November. So 1.5 years back, this had come. And after this had come, then a lot of cases started getting admitted. After this only. Before this, all the cases were just sine die till this order was come. Okay. Then they continued. They said A must observe the principle of natural justice when they are exercising jurisdiction under 100, when accepting, not accepting, rejecting, right? Also, they said purpose of interim moratorium under 96 is to protect the debtor from proceedings, and constitutional validity was upheld. 1421 is not getting violated. This code has no problem. Everything is fine. Let it go. After this, things are not going to Supreme Court for the constitutional validity, etc., etc., because that is settled now. It is pretty clear. Court bank can go against PG or CD or simultaneously, or PG first, CD later, CD first, PG later. All that is allowed. There is no problem with that. Okay. So Dilip Jiwarjika we have finished. So first was Lalit Jain, Dilip Jiwarjika. Third case, Dilip Kumar Singhania. This I think yesterday you have covered, if I am not wrong. This was in Justice Bhushan's court in NCLAT principal in
Yes, sir.
Delhi.
This we have covered.
Decided last, this you have covered. Okay. So 28th Feb, just for the people who were not there yesterday, maybe some has joined today. I'll just take 2 slides of this. In this case, SBI versus Deepak ji, the question was whether demand notice issued under 7(1) of the PGIRP rule can be considered as notice of invocation of guarantee. And facts of the case were LML case was there. SBI filed it. They went to DRT here and there. And since obviously why they must not have invoked it, because they thought limitation might come into picture. That 15 days time would have been gone. So this was, since you have done it, so I'm not getting into too much of it. Learned counsel for applicant, they said we have issued our demand. This should be considered as good as our invocation of guarantee. So I actually I had prepared a long slide for this, but since you have covered it, I will not go into it. 10A will straight away come to the decision. Decision of the NCLAT was definition of guarantor under rule so and so contains 2 conditions: who is a personal guarantor to a CD, and in respect of whom guarantee has been invoked. And obviously, if it remains unpaid in full and part. Now, both conditions have been held to be cumulative. That means both should be satisfied at the same time. A PG becomes a debtor only when guarantee is invoked. Now, and Form G can only be sent to that person where it is invoked. So that is why they say Honorable Appellate Tribunal rejected the application submission of applicant that notice under 7.1 of PGIRP invoking the guarantee is not correct. Default before issuance of notice must exist on the part of guarantor. Now, we don't know whether SBI will go to Supreme Court or not, but right now this is the law that first invoke, give them whatever time is as per the contract, and then only send the notice for payment. Okay. Fourth case was Mahinder Jijodia. Now, in this case, this was held bit like 27 Jan, so 2022, 3 years back. Again, same court, Justice Bhushan. Here, the question was, does section 60/2, 60/2 is, where can it be filed, or if you're aware,
Sure,
section
just
60/5, right?
can you go again to the previous slide? Yes, please. Just a moment.
This one?
That one, yes.
I'll be sharing this slide with you, sir. The
Okay.
PPT I'll share with you.
Okay.
So no need to write. So
Okay.
we are here just to make a mind map of ours. So Lalit Jain, whether CD discharge will release the personal guarantor? Yes, no. Dilip Jiwarjika, no,
Yes.
everything is fine. No natural justice is being honored. Everything is fine. Correct. Dilip Singhania, they said, whether demand notice is equivalent to invocation? Yes, no. Answer was no. Correct.
Yes. Yes.
Now we are coming to Mahinder Jajodia. Mahinder Jajodia, section 60/5, everyone knows, right? 60/5 is wherever nothing is there, then we come under this section, special powers. Rule 11 of NCLT, NCLAT, or 60. So 60 is that special thing. Here 60 was discussed. It said section 60/2 may, they say, whether NCLT has jurisdiction, NCLAT, that was discussed. 60/2 in any way prohibits filing of insolvency proceedings under 95 against the PG, even if no proceedings are pending against the CD. So this was the question, whether yes or no was the, now I have a exactly opposite, judgment also. We will learn how that is exactly opposite or not opposite. And that too given by a inferior court. So this was given by NCLAT. Now I'll also show you a NCLT order which does not say this. So here the question, as we say, 95 facts of the case. SBI filed an application under 95. This came to be rejected by the authority, saying that since no case is pending against the CD, forget it. Correct? So they say, since CD is not under this thing, let it, we will not do it. This appeal came into picture. Now what decision of the appellate tribunal was? Subject to so and so, AA for the corporate person, including the corporate debtor and personal guarantor, shall be NCLT. The subsection 2 of 60 requires that where a CIRP or liquidation process is pending before NCLT, related to CIRP. Okay, so this will go to such NCLT. Such means, so let's say the PG is staying in Delhi and the CD is in Mumbai. So the case will go to Mumbai, which is that jurisdictional, right? Wherever the main CD is there. Because main debt is of CD. This person is only a guarantor. So this will be transferred. Now, such NCLT was discussed. I don't think we need to go this much in detail. Now, here the appellate authority said A erred in holding that since no CIRP or liquidation of the CD is pending, the application under section 95 is not pending. They said no, this is wrong. If it is not pending, doesn't mean you can not initiate it in NCLT. The application having been filed under 95.1 and the AA for application under 95.1 as referred to in 60/1 being NCLT, the application filed by the appellant was fully maintainable and could not have been rejected only on the grounds that no CIRP or liquidation proceedings of the CD are pending. Now, this
Sir, in that
line
case,
I'm
it should be filed in, sorry to interrupt you, sir. It
yes.
should be filed in DRT, na? If there is no CRP liquidation is started.
No, sir, no, sir. That's what this case says no, it should be filed in NCLT. That's what I'm telling you.
So then it means DRT is finished. No, there is
Sir,
no role
आएंगे
of
वहां पे भी आएंगे. We'll come back to
CRP.
that.
If
So
there is no
I'll not use
CRP,
that word right now.
if
I'll
there
tell
is
you
no
why.
CRP,
Because
no liquidation, no IBC proceeding, and you
yes,
you want to start this, then to the best of our understanding, it was DRT.
sir, this is right in front of you, and this is not new. This is 3-year-old judgment,
Ah.
and obviously, since we are discussing it, that means it still holds true. Mahendra Jajodia said, pending, no pending. If it was over, the NCLT is the right forum. You initiate. It says this application could not have been rejected only on the ground that no CIRP or liquidation proceeding of the CD are pending. In result, we
Rejection is
set
okay.
aside the order. Sorry.
Rejection is okay. It cannot be rejected, but it should be dealt with at DRT or NCLT.
Sir, NCLT, no?
Why, then when DRT will come into play? In which cases?
सर पहले इसको कर लेते हैं. DRT is for personal people. They are not personal. They are PG to CD. And that
तो personal
intelligible
insolvency ना?
differentia,
Personal
so that intelligible
insolvency.
differentia is already there,
हाँ.
which Parliament has said we are only notifying to one category, which is
हाँ.
PG to CD.
Yes,
Since
we
they are
are talking about
different,
that
they
only.
can be dealt
Jurisdiction of that
differently.
only. Jurisdiction of that only. DRT versus NCLT.
Yes, sir. So NCLT has jurisdiction as per NCLAT order of Mahendra Jajotia, where they say application pending, no pending, doesn't matter. NCLT is the right place. They should not reject. They say we set aside the order of 21 passed by AA. Application filed by the appellant under 95 is revived before the NCLT, which may be proceeded in accordance with the law. This judgment is so very clear, sir. There is no ambiguity right now. Now, so this was which judgment, sir? Mahendra Jajotia 2021 Honorable Enclave judgment. Okay, I may come back to this judgment, after we discuss another case. So just keep it in mind. NCLAT said pending, no pending. NCLT is right. Okay. Now, in UCO Bank, Kolkata bench. Okay. This is NCLT. Okay. Not NCLAT or higher court. So NCLT is obviously, should follow what NCLAT is saying. But in this case, decided in 17th December 24. That means 4 months back, right? Vidisha Banerjee, Arvind Devanathan, I don't know. You don't need to remember the names. But name of the case was UCO Bank versus Subrata Das. In this case, see the question. Whether the present application under 95/1 of the code against the personal guarantor in the absence of an initiated or pending or concluded CRP against the principal borrower would be maintainable before this forum, or should the creditor approach the learned DRT? So what Anilji was asking, UCO Bank is answering. UCO bench versus Subrata is trying to answer. Kolkata bench. Sir, this was your question, Anil sir? Whether present application 95, should it go to DRT or should it stay with NCLT?
जी हाँ जी हाँ जी
Correct, sir?
Yes, sir.
Now, in this case, see, we have highlighted three words, huh? Initiated, pending, concluded. All three in apostrophe. Correct? Double apostrophe. So there is a reason why they are done like this. I'll explain you why. Facts of the case. Some facts let's cover. This application has been filed by a financial creditor, UCO Bank, to initiate insolvency of Mr. Das. He was PG to CD 95. No CIRP process or CIRP was initiated against the principal borrower. Now, the difference is there whether it is pending or initiated, right? In earlier case, NCLAT said if it is not pending or if it is over, doesn't matter. NCLT is the right forum. Here it was never initiated. Okay. Now what does the court says? Relevant judgment was this. Jajodia, the one we discussed, is one such case where CIRP against principal borrower stood initiated at a prior point of time before the NCLT and had culminated into a resolution plan. Therefore, it was not one such case where even without a CIRP being initiated against the principal borrower, the financial creditor moved the NCLT. Therefore, the said decision will lend no assistance to determine whether the NCLT would still have jurisdiction. Now, decision. It's little interesting to read if you want to. Honorable AA concludes, in terms of section 60/1 and 60/2, read with section 179, NCLT is only AA in respect to PG to a CD, where a CIRP or liquidation proceeding initiated is either pending or concluded. One more difference they have created now. So either it is initiated, yes, NCLT come, no problem. It was initiated, it's over, then also you come. Whether it's over by resolution plan or disposed of, whatever happened. Once the CD has touched NCLT, the golden milestone of NCLT, then no problem. But in the absence of an initiated or pending or concluded at all against a principal borrower, an application under 95(1) to initiate the IRP against the principal guarantor will not be maintainable before NCLT. The recovery proceedings will lie only before the DRT having territorial jurisdiction.
That is what I said. That is what we understood. No.
मैंने सर दो बातें कर रहे हो आप अभी. इनफैक्ट दे वो दो बातें कर रहे हैं देखा जाए.
हाँ नहीं
So
नहीं ये क्लियर है सर, ये क्लियर है. जहां
Yeah.
पे एज यू राइटली सेड, जहां पे एनसीएलटी टच नहीं किया है कॉर्पोरेट डेटर ने, आइदर इनिशिएटेड और कंक्लूडेड और पेंडिंग, वो एनसीएलटी है नहीं है, फिर डीआरटी है.
Okay, so nothing has happened in NCLT related to that. Then you go to NCLT then you go to DRT as per the order of NCLT Hyderabad. Kolkata. This is Kolkata UCO Bank, right? So in this case, they say then DRT. Whereas if it was started and withdrawn, started and finished, started and resolved, then NCLT Jajodia thing will come into picture. Then we don't mind, but till we are not agreeing. Now, as of now, I don't have knowledge whether it was challenged or not after that. But this is the decision, sir, of Honorable Kolkata NCLT bench. So obviously, one NCLT may take another view also, because NCLT is not binding on another NCLT. NCLAT obviously is binding. So here they clearly said, see, this is what they said. This decision will not lend any assistance to determine whether the NCLT would have jurisdiction. So it is a different forum. Not at all touched, go to DRT. Anything is started, come to NCLT. Now,
In
Anil
my
sir,
view, this is the right understanding, correct understanding, correct
correct, sir.
interpretation of the law.
Okay. Now, sir, if DRT is pending, and let's say now I filed an application at NCLT against the CD,
Then they say that it will be transferred to NCLT.
correct, right? So since it will be transferred, in my view, that is my
Whatever
personal, I mean,
hmm.
then it should be, then why don't you start it right away? What's the wrong in that?
That is also debate going on. Why to bring DRT at all?
Sir,
क्योंकि
6 months you will fight
हाँ
at DRT, somebody will
हाँ
file one application in NCLT and it will be transferred.
that is a debate. I think other day, very senior advocate was discussing with principal bench, and they were saying that this DRT versus NCLT should be resolved by now.
In my view, sir, nobody has gone to DRT.
जी हाँ.
People say the NCLT ही नहीं कर पा रहे, that what DRT will do. So I have not heard. Maybe some of us senior members might have experience, but I have not seen people going to DRT for personal insolvencies. Okay, so this was our UCO Bank case of Subrata Das. In another case, in NCLT Chennai, Kirtan Kumar Upadhyay, right? Here what happened is, what is the threshold limit to invoke 9495? Any idea what is the threshold limit of 9495? This is decided like, not even 1 month back. This decision has come. Now, what do you think is the threshold? Court said 1,000 and 1 lakh, correct? Higher limit 1 lakh, minimum is 1,000, correct? Now, in this case, application has been filed under section 94(1) of the insolvency by the appellant, Mr. Kirtan Upadhyay, to initiate the insolvency resolution process in respect of self. The CD had taken a loan amount of 75 lakh and appellant provided personal guarantee. The creditor, through the letter invoking guarantee, has demanded so and so. Now, when they demanded money, he initiated his insolvency. Now, with 75, what happens? Since it is only 75, CIRP cannot start. 75 lakh, correct? Now, decision of A, and this is a 94 application. The person himself is saying, I'm insolvent. IBC code decision was this. IBC code classify individuals into 3 classes. What are those? PG to CD, partnership firms and proprietorship firms, and other individuals, right? PG to CD, firms, but either proprietor or personal. And third is other individuals can be anybody, you, me, everyone, to enable the implementation of individual resolution in a phased manner. Now, central government, via notification of so and so, appointed 1st December 2019 as date of commencement for the provisions related to PG to CD. Now they say, thus, it goes without saying that the threshold limit to invoke section 9495 shall be same as is with respect to the CD under section 4. And under section 4, it is 1 CR. We know that, right? So as per A, Chennai, they are saying if it is below 1 crore, do not come to us. 75 lakh, no, this is not done. In this present case, the default amount is less than 1 crore. Therefore, the applicant does not meet the threshold of 1 crore to maintain this application. On page 1 there, page 6 there. So. Now, how many people think this is a right decision or not so right decision? Anybody would like to share? Or this should be the criteria.
Personal guarantee has been invoked in this case. I'm sorry, I was.
Sir, 94 is the
So if
when the
the threshold
person
limit is
when the
1,000,
person himself is saying there is no need of invocation. No?
no, that is himself is saying
Yeah,
that in the personal insolvency, the threshold limit is 1,000.
correct.
So if he is defaulting 1,000, the personal insolvency can commence.
Yes, but the NCLT is saying no.
I
And
don't
this is the
understand the
reason they are giving.
jurisprudence. What is the rationale? You can explain better why they are
Sir,
saying.
jurisprudence, this has happened, you know the date of this order? 19th March,
Yeah,
25,
yeah.
15 days back. So 15 days back, they said no. If the threshold under CIRP thing is 1 crore, so let it be 1 crore, below 1 crore, do not come. We are not admitted. So that is the decision, sir, right now. Right, wrong, I mean, this is just talks. End of the day, this is right now the
Then
situation.
why they have prescribed 1,000 there? They should have said ki if the corporate debtor is defaulting above 1 crore, then they should have added there.
So, sir, as we were discussing in the beginning, code is saying, now they may say that 1000 is when, it's applicable on the entire code or on the entire chapter 3. When personal insolvency will also start, individual insolvency will start, maybe at that time. Right now, since you're coming to NCLT, see 1000, if you want to do, go to DRT. Poor cousins. You want to come to NCLT, come if you have enough money defaulted. If you have 1 crore, then
That
only.
is okay. They can go to DRT. That is fine. But they are not saying that a process cannot
No,
be started.
no, sir. They are saying it cannot be started at NCLT under
Ah,
section 94.
because corporate insolvency has not commenced. As you rightly said in the previous order, previous
Yes,
judgment, that
yes,
if the CD has not touched the door of NCLT by way of initiation or pending or conclusion, then
correct.
the right forum is DRT. So that is what they are saying.
That is said by one of the NCLT Kolkata, UCO
Hmm.
Bank.
But
Correct.
that is the correct
Now this is a
interpretation.
different one. Correct. So this
Hmm.
is a different one by NCLT saying if 1 CR is not there, then you don't come here. Right. So they gave a different reason. They did not say that it has not started. That is why don't come to us.
No,
They are
they are
saying
saying it
since
will
it
not be
is
able to
one will
touch. This company will not be able, they will not be able to get initiated. CRP and NCLT, same thing. Initiation will not happen.
absolutely, sir. So right now two are according to you two are same thing, right? Okay.
Yes, sir. Yes, sir.
Now if this judgment is there, have you heard of PPIRP, sir? Per pre-package insolvency.
जी हाँ जी हाँ जी
Now pre-package, what is the threshold?
I think 10 lakh.
10 lakh. So if pre-package is 10 lakh, then this should also be 10 lakh.
हाँ.
Then why 1 crore you are looking for?
Hmm.
But the CD could have gone into pre-package, no?
But they have fixed different thresholds for different processes. That
Correct,
they,
sir.
if they want to harmonize, they can harmonize. But as of now, these are the threshold limits.
I know that, sir. I'm only saying
Hmm.
why they are saying 1 crore. Why not 10 lakh? Why they assume that only CIRP can be started against a company?
Hmm.
Why not PPIRP?
So NCLT jurisdiction, they did not discuss about the PPIRP. PPIRP is extended
That
form of
they
OTS.
could. Sir, again, this is the decision. It is right in front. I'm not denying that. I'm only saying, suppose PPIRP can also be there, right? In that case, then this will not be correct. Then even in 11 lakh person can go. The moment PPIRP application is filed. So what is the way out? In my view, suppose I'm an advocate, we will ask them to file a 54C pre-package. and after that go to NCLT and say that since now default is so much, so are we eligible? Then obviously it will be eligible. But right now, agreeing with you, Kolkata said if nothing has happened, don't come to us. NCLT Chennai said if it is below 1 crore, don't come to us because it's related to CD. Fine. 2 cases. Now, next one is 7th case of Rakesh Bhanot. I hope this was also discussed yesterday. No,
No, it was not.
this was not. Okay. This is again, many petitions were there, SLPs, etc. Delivered on 1st of April, 1 week back, 10 days back. In this case, Justice Parthiwala and Mahadevan, what is the question? Whether the proceedings initiated against personal guarantor under NI Act of, Section 138, 141 is check bouncing cases, right? Whether they should be stayed upon filing of application under 94, 95 in view of the interim moratorium. Now, obviously, every PG will say, yes, they should be stopped. And every other person will say, no, they should not be stopped, isn't it? Now, in this case, facts of the case were there are multiple impugned order, but the facts and issues involved in all these cases are common facts arising for SLP. So, this is also a major case like in Lalit Jain, Dilip Jiwarjika. This is Rakesh Bhanot. Just remember the name. Rakesh Bhanot versus Gurdas. So, see, Dilip Jiwarjika is one person. There were 800 more, 300 more. Only the first name is normally mentioned, then that is why. So, in this case also, there were many people who approached Supreme Court saying that now moratorium is there or interim moratorium is there. Our NI proceeding should not continue. And Supreme Court in all these batch of petitions have decided it by a common order. Now, the facts is they went to Supreme Court. Gurdas Agro filed a complaint under 138 of the Negotiable Instrument Act against so and so Holdings Limited, and the director Kiran Bhanot, wife, etc. They filed. It was alleged that it was alleged in the complaint that accused gave 4 checks of 50 lakhs each in Ludhiana, blah blah blah. It was so simple as this was pending. Now, during the pendency of the proceeding, the appellant Rakesh Bhanot filed an application under 94 and they said now it cannot be proceeded, so it has to be finished. Pending the insolvency proceeding, the appellant moved an application before trial court for adjourning 138 proceedings sine die. You know what is sine die? Sine die is till this thing is over. So till then you forget it. So sine die is till that result has come, till then you cannot take any decision on this. Trial court via order dated 3/5/22 rejected the aforesaid application. Court said nothing doing, we will continue it. Obviously, when they continue, agreed by the same, appellant approached the High Court of PN Punjab and Haryana, filed a criminal petition 482. 482 is for quashing of this. By order of 23, the said criminal petition came to be dismissed by the Honorable High Court also saying, obviously when they lost in I think I'll have to mute Ajay. Okay. Now, so trial court said no, nothing doing. High Court also said nothing doing. 138 will continue. So when they lost both of the places, they went to Supreme Court. Now, what Supreme Court has said in this cases, they said scheme of thing. So they explained the legislative intent behind IBC is to provide a structured framework for the resolution of CD who is under financial distress, facilitating their rehabilitation and ensuring the maximization. Now, moratorium under section 14 or 96 of IBC, 14 for CD and 96 for person, is restricted only to protection against civil claims. So here also, in case a partnership firm, the interim moratorium protects only the firm. But in case of company, such protection is available only to the company and not to the directors. So discussions were happening. Moratorium provisions under IBC offer protection only to CD and do not extend protection against civil liability to personal guarantor. I hope this is clear. So check bounce of a CD will be stayed against the CD, not against the director. Same way, it is not stayed against the personal guarantors also. So this is what they are clarifying here. Interim moratorium under 96 and moratorium under 101 are designed to offer a breathing space to the CD, allowing them to reorganize their financial affairs without the immediate threat of creditors' action. However, this moratorium is not intended to shield individuals from personal criminal liabilities arising from their action outside the scope of corporate debt restructuring. Again, so they see when it's a writ petition and batch of petition, normally they give a lot of observations on that. They want to, close once and for all. See, Lalit Jain case came in 21. Then Dilip Juarjika 23. Now in 25. So every 2 years, things are, piling up, and then Supreme Court clears the way. This is 25. Here, interpretation of terms, any legal action or proceedings in so and so. Answer is simple. Only recovery is stayed. So term, when it says term, any legal action or proceeding does not mean every legal action or proceeding. So they said any is not equal to every. So in subclause 96B1 and the term legal action or proceedings are followed by the term in respect of any debt. Now, check bouncing is not only debt, it's a criminal offense, they say. Now, the term legal action or proceedings would have to be understood to include such legal action or proceedings related to recovery of debt by invoking principle of nocitera sos. Now, this means nocitera association, I travel by bicycle, scooter, and I can't say aeroplane. So it has to be two-wheeler kind, right? So that is nocitera association says. This is not important. Statutory liability against the directors under Section 138 of NI Act is personal and continues to bind natural person irrespective of any moratorium applicable to CD or to PG. So I think with this, it is pretty clear. Except, and again, this also they have clarified, nothing doing, they will not have any effect on the prosecution. Distinction between the right to sue based on a dishonored check by initiating a civil suit and launching a prosecution. Okay, this we will learn. But here they said everything can be done, no problem. There is no restriction on this. No bar for continuing of any criminal proceeding. Now, let me discuss it a little bit better. Distinction between the right to sue based on a dishonored check by initiating a civil suit and launching a procedure. See, 138 can be launched only within 1 month, correct? After 1 month, if you want to do, it is only a civil suit for recovery of your money. That is separate. Now, cause of action for prosecution under 138 of NI Act commences on the dishonor of the check and failure to pay the amount because of dishonor within 15 days. It is pertinent to mention here that the prosecution can only be with respect to the amount unpaid by dishonor. So actual debt might be 10 crores. You have given me a check of 5 lakh. So 138 can only be initiated against 5 lakh, correct? Distinction between the right to sue based on a dishonored check by initiating a civil suit and launching a prosecution under 138 is significant. In case of the former, interim moratorium can operate, but not in case of the latter. So when it is a quasi-criminal proceedings, it won't be stopped. They will continue. The first one, it may not, so they did not touch it up. Now, judicial precedents were discussed. P. Mohan Raj was another case, this case, that case. Uh, this case was discussed yesterday, no, because this is also an interesting case that Ajay Kumar Radhesham Goenka when it comes to personal insolvency. In this case, it said that, even if the CD has been dissolved, everything is over, NI will still continue. So this was the case where they said this was also discussed. Conclusion was very simple. Object of moratorium is only to enable the debtor to approach the tribunal, but not to stall the criminal prosecution. It is only to postpone any civil action. That's all. And since 138 is criminal proceedings, quasi criminal, they should not be stopped. It will continue. So after an Supreme Court, please advise your clients accordingly that no, they will not be stopped. There is no bar on that. So this was the case of, what is the name, sir? What is the name? Rakesh Banot versus Gurdas Agro. Fine. In this, 138 will continue. Okay. Now, case number 8. Case number 8 is Suresh Atlani versus Omkara ARC. This is again delivered this month, 4th of April, related to our PG thing, delivered by NCLAT Principal Bench. In this, I think you have covered this yesterday. 10-day period, whether it is mandatory or recommendatory, and whether and can there be a challenge on this ground or not? Whether report which is submitted after period of 10 days can be taken on record by AA or not. Now, I think you know the answer. Answer is DHFL, that
Yes.
Diwan Housing, Piramal, etc. Right? So in this case, they said 10 days only is not, you know, uh,
10
not
days are not
mandatory but
mandatory.
directory, and then it should be allowed. Now, don't go with this premise as an RP. As an advocate, no problem. Okay. So challenging is not a problem. They allowed. But IBBI will be after your life if you don't do it in 10 days. So try to close it within 10 days and whatever best you can do at your part. So yes, 10 days is directory, not mandatory. And after that also, AAs have the powers to take it down. That is the whole decision. Now, I'll share this PPT. It has all, what are the facts, etc., etc. I don't think is really important to get into it. Shall, blah, blah, we have discussed. Use of expression shall, although generally indicates mandatory nature of provision, but use of shall is always not conclusive, and the expression shall cast a mandatory duty or only directory depends on the scheme of statute. So it's all about words, huh? How the words are being used. So, I mean, as an RP, I would love this order because it gives us little bit leeway, and yes, we go with this.
Technically, 10 days are not sufficient, sir, to
Yes,
submit.
sir, I agree on that, sir. Certainly, you're right. Because many a times we don't have a phone number, we don't, and they also say that, we have done, suppose they have taken 200 crore, 300 crore. How do you
Yes.
expect them to reply you, with all their things within, Nobody is running.
Even the applicant do not reply within 10 days. The financial creditor, those
Exactly.
who have
Even the
appointed
banks
you,
don't answer.
those who
Yes.
have appointed you, even they and
Yeah.
their counsel do not have the requisite information.
Yes, I'm aware of that, sir. There are many times we end up taking dates just because the bank's advocate is not able to give the. I remember, sir, one case, 3 dates we took only because of one thing. Court wanted to know what is the recovery you have done in the CIRP process. What is the amount of recovery you have done in CIRP process? So that that much amount can come down from the PG, correct? There is
No,
nothing wrong in that.
that is also
And
important. But you have
obviously,
to
sir. So
contact the RP and take the resolution plan, how much he has paid, so that we know the exact amount.
correct, sir. So just to take that information, it took us 3 dates at NCLT. And it was not NCLT's mistake, sir. It was bank who was not able to provide the information. Only reason was the CD was resolved 2 years back. And then nobody knows how much is still due. So yes, you're saying you're right. 10 days at times feels very stringent. But sir, that's how the code is. So that's how the code is. So no comment on that. Now, period of 10 days provided for submission is not a period of limitation prescribed from doing an act. So all that the detail is there, so we don't need to get into. This was also fine. Conclusion is, even if it is 12 days, no problem. Okay. In fact, this is one of the case of Anilji himself. Anilji is sitting with us. NCLAT Principal Bench, Anil Kumarji versus Mukund Chaudhary. This was decided in 22nd of Jan this year itself. Here the question was whether extension of moratorium, which is so our code says within 120 days we submit that repayment plan 112 report and then code will take a decision yes or no. Moratorium under section 101 is for 180 days. Now, after 180 days, there is no scope of extension. So, like in CIRP, there is exclusion, extension, so many things. In our in PG, there is no extension. There is no discussion about that. But maybe under special powers you apply, and if they allow, whether extension of moratorium, which is statutory prescribed under 101, can be extended by the AA or the appellate tribunal. That is the question. Also, whether moratorium period prescribed under section 101 of the IBC is only directory and can be extended by the AA in appropriate case. What happened here is, on an application filed under 94(1) of the IBBI, AA passed an order declaring moratorium. RP, Anilji, filed a report under 99 of IBC. Report was considered by AA, dated so and so. Section was admitted, and so 30th 4 it was admitted. 30th April last year. 101 was commenced. 180 days was supposed to be over whenever they were over. 2810. RP was authorized to file an appropriate application for extended PIRP by 90 days. Now, RP thereafter filed an IA seeking extension of 90 days. AA rejected the application. So, what AA does in this case is they allowed the extension, but they did not allow the moratorium,
But they were not very happy
right?
to allow.
Sir,
They allowed because
we will come to you, sir, because
Hmm.
we would love to hear from you that what is the exact status of this. So, as per the facts of the case at NCLAT, they allowed the extension, though they were not very happy to allow, as you rightly said, but moratorium they certainly did not extend. Now, obviously, agreed by this, appeal was filed. And Anilji, I think you only filed this appeal, right?
no.
This was filed by the bank, right?
This appeal was filed by me, though
Correct,
there was a deep discussion on that also. Who is the
correct,
aggrieved party? So,
correct, correct, correct.
and you were party, you were party to that discussion. So,
Yes,
what has happened in this case, there are two person guarantors. One is Mr. Mukund Chaudhary and his wife, Mrs. Jyoti Chaudhary.
correct.
And what has happened, sir, the 180 days got expired. So we approached Honorable NCLT for extension of the time because the personal guarantors were willing to submit the plan. And the creditors were negotiating every time they were holding meeting, and they were requesting personal guarantor to improve the repayment plan value. And he was agreeing that he will approve.
Improve.
And the creditors also requested for the fresh valuation of the asset. So all these, and they also appointed asset tracing company. So though there is no provision in PRP to
Correct.
go for the
There is no
valuation, to go for the asset tracing report, we did not link it with our final report. We said it was stated in the repayment plan, any asset is found that will be handed over to the creditor.
Okay.
But all this process, because 5 rounds of the creditors meeting took place, and we explained to Honorable NCLT, and they were not very happy to allow. They say there is no provision for extension.
Extension, there is no provision, correct.
But at the same time, this became a case law because there is no. It does not say that what will happen after 120 days. The moratorium will finish after 180 days. PRP
Correct,
has
sir.
to finish in 120 days. But what
Correct, sir.
happens if the PRP is not over?
Absolutely, sir.
There is nothing in the code.
Right, sir.
There is nothing in the
I-
code. So
In
if
fact,
we-
CIRP has that provision that
Yeah.
if it doesn't come straight away liquidation. Here that option is not there.
No, you apply for the extension. If you do not
Yeah.
get the extension, then liquidation starts. Here,
Correct,
here for bankruptcy trustee, you have to take a liberty and file a fresh application. It is not
Correct, sir.
automatic.
correct,
So
correct.
NCLT with lot of insistence, seeing the practical viability that the repayment plan can come and it can get approved. So they, in both the cases, they allowed the extension. But NCLT, Honorable NCLT clearly said we are not commenting anything on the moratorium. They said in the NCLT order, they wrote one line, we are not commenting anything on the moratorium.
So they didn't say yes or no, nothing
They
they
didn't
said.
say yes or no. So this,
Okay.
this gave a sense of worry to the personal guarantor because in that case, creditor can initiate the action in a surface side because that
Correct,
was
sir.
already
Yeah.
in force. So,
Correct. As long as they are silent, yes, right.
so there nobody can stop them. So he, in order to protect himself, though I was not very keen to file this application.
Okay.
I was not very keen because I am not the aggrieved party. It was discussed.
Absolutely.
And with
Correct.
some senior lawyers also it was discussed that why should you go? Otherwise,
Sir, in fact, IBBI also say that RP cannot be aggrieved against NCLT order. So how can
NCLT
RP
order.
go?
But here, finally, the view we took, we want to understand whether the extension is possible or moratorium is applicable or not. We
Fair
went
enough.
from that perspective. We didn't pray that you give moratorium to this party. We wanted to
Sir,
understand.
just 1 sec. I'll hold you here, sir, once.
Yeah.
So for our audience, in CIRP, if there is extension, moratorium automatically gets extended. Because there they say section 14 moratorium is till the CIRP is continuing.
Yeah.
So till the CIRP means extension is there, so moratorium also automatically. Here there is no such thing. Since there is no such thing, that is why this confusion came into picture. Yes, sir,
And
please
no,
continue.
but here it is very clearly stated after 180 days, moratorium will end.
Exactly, that is a problem.
Rather,
Yes.
rather it says that. It says
Rather
that
it says that. Yes,
PRP
yes.
should be finished within 120 days. So this
Correct,
is
sir.
also contradiction. When the PRP is finished, what is the purpose of moratorium? What the RP will do? PRP has to be completed within 120
Yes.
days. So
Correct, sir.
all these needed some clarification. So from
Correct.
that perspective, we approached Honorable NCLAT. And Honorable NCLAT says we are not discussing. So now the PG has gone to Honorable Supreme Court.
Right. So here what happened is appellate tribunal in this judgment, they discuss, some new tech promoter, developer, blah, blah, blah. Here also, so interpretation, this is what they gave. They said language of section 101 is plain and clear. Outer limit of moratorium is prescribed by providing that 180 days from the date of commencement of admission of the application or an order is passed by the AA on the repayment plan, whichever is earlier. Thus, on happening of the eventuality 101 moratorium comes to an end, conceding any power to the AA or this tribunal, that means appellate, to extend the said period shall be plainly against the statutory scheme of things. So they
Yeah.
are so clear. As per NCLAT, they say neither we have power, neither NCLT has power, because on Parliament has clearly said 180 cut, or the repayment plan is done, cut. So repayment plan can be before 180 days also, correct? So
Yeah.
before that also it will be over, or 180th day it will be over. And so that is why the reason of 120 and 180 days. They say finish within 120 so that within 2 months NCLT can take a decision and say yes or no on the repayment plan.
Yes. So,
Now,
but
yes,
that gets mixed up. Even that period, the meetings continue and the repayment plan is being made, and then uh, virtually 180 days are used for that purpose.
correct.
So we approached
Correct.
on our NCLT only after 180 days, not after 120 days.
I know that, sir.
That
We
goes
only
thing.
go after 180 because 180 we already have moratorium. So,
Ah,
and
so
our job finishes
as
the
such, we
moment we
should
file
go.
it.
As such, we should go after 120 days.
Exactly. So
Ah,
ideally we should go after 120 days with the plan. Since there is no plan, we should ask extension at that time itself.
yes. So that was one question to be decided. So these two questions, whether extension is possible or not. One interpretation was that since there is no need for extension, it means PRP continues, except moratorium will not continue for endless period. How can
No,
it be endless period?
then it will be endless. Yes, then
Endless,
it will
yes.
be endless. No,
So,
and if it closes,
hmm,
suppose if it gets closed, 180 days is over,
yeah,
then do the creditors automatically get a right to initiate bankruptcy?
yes, sir. That is not the case, now, sir. Here, you have to
Exactly.
file a closure report on the second 1 month.
This is a very vital question. In 120
You,
days, no repayment plan has received. Thereafter, we wait for the after filing the application before the NCLT under section 106 and wait for 180 days till if or no order will come. We should continue for the further direction. But automatically after 180 days, it has been freezed. Moratorium has completed. Then the RP should go automatically for the bankruptcy
no,
file
no, no, no.
application, or what the situation will be at that point of time.
No, sir. Let me
Sir,
explain you, sir.
121 section clearly says once that is over and you have to attach that certified order of closure of 94 or 95.
Can I explain
Without that,
what
you
we are
can.
doing?
Yes, please try.
Yes, Mr.
Yes.
Sir, what we are doing in cases where we have not received the repayment plan, okay, we are calling a meeting of creditors and requesting them to allow us to file the closure report. Even if they don't allow, we will go and file the closure report. And we are telling creditors to take a decision whether you want to proceed for bankruptcy trustee or not. If they say yes, then in our closure report we are writing, give us the liberty to file a creditor or debtor a bankruptcy trustee application. So closure report has to be filed, and
Only
fresh
two options. One
application.
is the bankruptcy trustee, another is foreclosure.
No, bankruptcy trustee comes later on, sir.
Okay.
It has to be filed. It has to be filed after the PRP process has been over. So for that, after the period is over 180 days, and there is no repayment plan, and we have not sought the extension, and there is no possibility of getting the repayment plan, then we must file the closure report. If there is a possibility, we should seek the extension, because in one of the cases, Ranaji, you were involved, the Honorable NCLT itself said, go again to the personal guarantor and ask him to submit the plan. So they themselves are pushing us to get the plan, and that period is already over. 180
Long
days.
over, sir. Long over. Long
Long,
over.
long
In
over.
one of
So,
my case, after 2 years, NCLAT Chennai told me, why don't you consider their plan?
huh,
After 2 years. So,
If the repayment plan is less, then say on what basis you dig out. So we have to explain there is no provision for forensic audit, there is no provision for investigation. So we have tried our best. So we after exhausting all the option, before
Yes.
taking, preferably after taking creditors into confidence, file a closure report.
I am
And
facing the same problem actually. I am facing
Yeah.
the same problem. 120 days going to be completed shortly. And the CD personal guarantor said, I am not in position to submit any plan. And COC told, you just appoint some detective agency and wait for their report. After 120 days, I have only further 60 days, no extension is there. And as per the recent NPR decision, they will not allow for the further extension in the moratorium. So this is a very gray area. How in
no,
within
no,
60
no,
days?
sir.
Yeah.
Let me come and help you.
Yes, sir. Yes,
See,
sir.
there are two situations. One is there is a possibility of getting the repayment plan. The discussion is going on, and
Mhm.
creditors are telling the personal guarantor to improve the value. That is one case.
Mhm.
There you have to uh, convince NCLT to give you extension. When the creditors are requesting you to wait endlessly till the report of the asset tracing comes, there you don't have to agree. There you have to say, no, let us first file our closure report, and this asset tracing and all those investigation can continue if you want to start the fresh process of bankruptcy.
Yes, process of the bank.
So let them file a separate application for the bankruptcy trustee, because you complete, otherwise you will be getting into a lot of problems with NCLT and IBBI.
Exactly, sir. Exactly.
Because there is no provision of valuation and a forensic
Exactly.
audit and investigation and asset tracing in PRP.
Yeah.
So for that you cannot delay. During CRP we have right to appoint forensic auditor, transaction auditor, do investigation and all those things, because we are supposed to file proof of application.
No,
It
since
is
we
not
all are
like that.
here,
Yeah.
we all are here. Anybody would like to tell me, discuss? I mean, when you tell me, then means you are telling everyone. What do you think? Bankruptcy should be a separate CP or should it be an IA?
I think separate CP,
Okay.
That technically you are the best.
because this is a
No,
completely
ये हमको यहाँ पे फंसाओ मत आप राणा साहब. ये टेक्निकल क्वेश्चन पूछ के
I'll tell you. I'll tell you why this question is there.
ये
See,
आप एडवोकेट
separate
वाले
CP.
क्वेश्चन आरपी से पूछते हो.
नहीं सर, ये एक अच्छा क्वेश्चन है सच बताऊं तो, बिकॉज आई फाइल्ड एन एप्लीकेशन लास्ट वीक. वहां पे गलती से क्या हुआ है, ऑर्डर एनसीएलटी बेंच 3 व्हाट दे हैव डन इज they have taken the report. They said report taken on record, and the report said close the PIRP. Now taken on report, but they did not close the PIRP. अभी क्या करें?
Closer ना.
Exactly. Sir, now that is
Sir, in your
interpretation.
prayer, what you are saying?
Yes,
What is
yes,
your
yes.
prayer? Your prayer is
My prayer is take on record and close the CIRP
and pass any other order.
and pass any other order,
So
obviously.
there,
So
so it is closed, sir.
नहीं सर, वही
आप
तो
अपना
प्रॉब्लम
केस
है.
उठाना
So,
चाहते हो,
sir, I
क्लाइंट
got
को
your
रखना
point.
चाहते हो तो अलग बात है.
नहीं sir, my problem is if it is closed, then I have to attach that with my new application under 122, 123.
Yes.
Correct?
Yeah.
And for that, I need a certified order of the NCLT. Now,
Yeah.
that order only says one line, report taken on record, subject to all just exceptions.
So that is the interpretation. That is the closure.
नहीं तो sir, dispose of नहीं आ रहा ना, it is still showing pending. So that first CP is showing pending. That should be disposed of, isn't it?
हाँ.
वो
Application
नहीं हो
should
रहा
be
है,
disposed of.
वो नहीं हुई है.
वो चाहते हैं कि आपको फीस मिलती रहे, 2-3 बार और भी जाओ आप.
No, I am happy वो चाह रहे हैं, अच्छी बात है sir. So ऐसा भी होता है. That is why I said, and that is where this idea came. I said, why not a separate IA to initiate bankruptcy itself?
Yeah.
Why separate CP? Because end of the day, this bankruptcy can only be initiated after this is over.
Yes. And
Now,
upon the
since this
application
is
of debtor and creditor.
exactly. So why can't we file an IA here itself and
Yeah.
start the bankruptcy?
Yeah. We should attach the order, and that is what we are doing.
Is there on? No, sir, that's not what you are doing. What you are doing is we are always filing separate CP. CP is
Ah.
company petition, a new petition.
Yeah.
I'm saying I don't
No, no,
want to
IA,
file a new
separate
petition.
CP. We will file separate CP, not IA.
पर सर सीपी के लिए इस सीपी को तो बंद कराऊं कि नहीं? इस सीपी
बंद
का
ही हो
ये तो
जाएगा
अभी
जब
ओपन.
वो अपने आप उसमें ये भी लिख देंगे इसको भी बंद करो साहब। अब ये तो
Okay. Maybe we are filing for
हाँ,
another application for
हाँ,
clarification.
एक
So,
और वहां पे आइए फाइल कर दो सब बंद करो इसको।
so
अब,
as in Anil Kumar
Uh,
sir's case, this one NCLT said we will not extend the moratorium, and now this matter is before
now the
Honorable
personal
Supreme Court.
guarantor has approached Honorable Supreme Court. Honorable
That's-
Supreme Court gave two meaning. I shared with you, sir, the order today. If you want, you can show. You know, so there they said we cannot challenge the constitutional validity of the law. But
Okay.
at the same time, they said that without moratorium, the objective of the PRP and the insolvency process will be defeated.
Correct.
So they have given a liberty to go back to the civil court and discuss it out, and they called matter is pending.
So they did not say anything. So when they did not say anything, that means NCLAT order will be valid, and that means right
They have
now.
dismissed the petition, but they have given this
Some
observation.
finding, right?
Yes.
Okay.
So it means
okay. So
this issue needs
maybe,
to be resolved.
sir, maybe that has come
Supreme
today.
Court will
So
resolve.
maybe
Supreme Court
in
will
next
resolve.
case we will discuss
Yeah,
it
they
next
will
class
resolve.
maybe.
हाँ.
Right now, my last case today is Saranga Anil Kumar Agarwal and Bhavesh Dheeraj Lal Seth. This also came in March 25 by Justice Vikram Nath and Varale. In this case, the question was whether execution proceedings under section 27 of the consumer, like NCDRC, consumer protection, all those cases, whether they will be stayed during interim moratorium or not, and whether the execution of penalty order by NCDRC can be stayed. So consumer protection execution can be stayed or not. That is the question answered by Honorable Supreme Court in the case of Saranga Anil Kumar Agarwal versus Bhavesh Dheeraj Lal. Now, in this case, so 138 we have discussed. 138 was which case? Which matter? Name of the matter. Just now we learned.
NOG.
Rakesh Banot, correct. Rakesh Banot versus Gurdas Agro. And this is second case, which is Saranga Anil Kumar Agarwal versus Bhavesh Dheeraj Lal. Here they say not 138. Consumer protection. See, now slowly if you see, IBC tha na that, non-obstante clause, everybody else is down us. Now slowly they are creeping in. 138 is now back. Consumer Protection Act 27 is coming back here. You will see. Here NCDRC allowed that, construction should be done. Penalties were imposed on the developer. Now this developer, they said, now moratorium is going on, sir. So this cannot be done. Now, and even under personal guarantee, there is, so NCDRC, while impugned order 24, rejected the application, holding that consumer claims and the penalty imposed does not fall under the moratorium. Now, NCR, Anil ji, I think you'll have to, Ajay ji, yeah, thank you. NCDRC concluded that the interim moratorium under 96 did not bar the continuation of criminal proceedings under 27. Here also, NCDRC also, criminal proceedings will continue. Decision said, penalties imposed by NCDRC are distinct from debt. They are not debt recovery. IBC moratorium is only for debt recovery. This is not a debt recovery. This is a penalty. Since it is a penalty, it should not fall within the interim moratorium.
Yeah. It is extension of that decision.
Exactly. So now Supreme Court is pretty clear. So you can see within 1 month, two different decisions saying both are allowed. Punitive actions and criminal proceedings will go on, and 101, 96, 14, they will not work on that. Mens rea. Mens rea means bad mind, criminal mind. It is to stop that, not for any debt recovery. And then they, go on discussing what is the difference in 14 and 96. That also was discussed little bit. since we don't have much time, I'll only come to this. Penalties imposed by NCDRC are regulatory in nature and do not constitute debt under the IBC. Moratorium under 96 does not extend to regulatory penalties imposed for non-compliance with the consumer protection law. So NCDRC came back, NI 138 came back. So it is there that you have to advise. Last slide of the day today, cases covered. These are the cases. Lalit Jain, whether resolution plan discharged the personal or not? Answer was no. Dilip Juarjika, report of 99, natural justice, etc. It was upheld by Supreme Court. In Dilip Singhania case, just now we learned, invocation of personal guarantee and demand notice is equivalent. Answer was no. Mahendra Jajodia, if no proceeding against CD, then can 95 be filed at NCLT? Answer was yes.
आप हमें एग्जाम की तैयारी करा रहे हो लगता है.
And you, sir, just to see,
Yes, sir.
as an RP, I believe 7, 8, 10 cases you should
नाम याद करा
remember.
रहे हो और yes or no भी लिखवा रहे हो.
Sir, कुछ yes no रहना चाहिए so that it makes a mind map to you.
हाँ.
कल change हो तो कुछ नहीं, आज
हाँ.
ये status है. Proceedings, अगर if nothing is started against the CD, then NCLT said no, go to DRT. The answer was no. Kirtan Upadhyay, they said threshold shall be same as CIRP, which is 1 crore. Rakesh Banerjee, 138 can start. Supreme Court said yes, it will continue, no problem. Similar was Saranga Anil Kumar ji. NCDRC execution is also criminal, so it should start. It should continue. Anil ji ka case हमें पता ही है, moratorium we learned. And Suresh Omkara case was whether 10 days report is mandatory or not. So with this, I guess 5:30, we are closing it on dot.
Thank you so much.
I don't know if I can share on chat. Maybe I'll share with the anyone interested in this PPT by any chance?
Yes,
Yeah,
sir.
please.
Yes, sir, please.
Sir,
People
please
are
share
okay.
the PPTs with me. I will share with the participants.
Okay, you want to share? Okay, I'll share with the
अंजलि मुझे
Anjali ji
पेमेंट लिंक
and-
भेज देना ताकि मैं कुछ क्रेडिट तो ले सकूं. आई वाज कॉलिंग यू.
सर मैं
Otherwise,
ट्यूसडे को करवाती हूँ, मंडे तो ऑफ है, ट्यूसडे को
हाँ.
करवाती हूँ.
जी हाँ, जी हाँ, जी.
otherwise let me put it in chat. You can download it from here
वो तो
also,
थे,
and I'll
आपसे तो
share
हम ले
with the
लेंगे कभी भी, पर
Anil ji is my partner in RRR also. So thank you, Anil ji, for being here and
thank you, sir,
making it
for
an interactive
Sir,
session.
I will take
Uh,
care of
Sir, very
it.
good session, Rana ji.
जी हाँ, जी.
Thank you, sir.
Thank you very much, sir.
uh,
Your session was very wonderful and interactive for the participants and for me also.
अब हम एग्जाम दे सकते हैं इसका. केस लॉ नाम भी याद करा दिया.
नहीं, और कभी हम बैंक्रप्सी का भी ऐसे ही करेंगे, बिकॉज बैंक्रप्सी
ये
आल्सो
इस
इज अ
तरह के
प्रीटी
कठिन
इंटरेस्टिंग फील्ड.
इस तरह के इंटरेस्टिंग
Sir,
क्वेश्चन मत
it
पूछा
was
करो.
very interesting since CIRP तो अपने accustomed हो गए हैं. Personal insolvency, personal guarantor में ग्रे एरिया भी है, प्लस बहुत ज्यादा क्लैरिटी ना तो जुडिशरी में भी है ना अपने प्रोफेशनल्स में है. तो लाइक दिस टाइप ऑफ सेशन मतलब डेफिनेटली हेल्प अस.
Yes, sir.
And
Yes.
sir, we are also learning with you. Nobody is
It's
perfect.
your greatness, sir, but you
अगर हम
have
perfect
given a
होते
very
तो
good observations of the courts and other issues.
okay. Pleasure is mine, sir. I think
थैंक यू
I'll
राणा जी.
stop it. Okay, Anjali ji, then we can wind up. Thank you for the
Once
day.
again, Sam. Thank you.
Thank you, sir.
Thank you very much, sir.